Yes.
My lord, yesterday I have filed one with IA, my lord. Let the matter be listed on Thursday.
What is the matter about?
Matter is, my lord, regulation of the service of the petitioner.
Okay, okay.
Yes, my lord. And further, my lord, swear God, I am not keeping well today, my lord. So,
Not keeping well.
yeah, my lord,
Bad
I've been
case.
sick actually.
Bad
So,
case.
yeah, I would like to mention, I am to consent also 28, 29, and 38. In 38, my lord, there is
28, 29.
28,
Okay, NPS.
29, yes,
Huh?
28 and
You
28.
don't want the new pension.
No, not pension case. This is a non-payment of salary. Judicial colleague, my lord. 28.
Okay, okay. 28, 29. Yes,
Yes,
yes.
similar
Yes.
tag. And then my lord, 38. 38,
38.
I got injury, my lord. That case, that case, my lord. I got injury
Exemption from promotion.
forgo, yes, my lord. I have also prepared written argument, of course.
No, I don't need
21-3.
written. I just want oral submission. That's
My lord, let the matter 21-3-2005 year lawsuit has passed an order in item 38.
okay. I
So
know.
it
I've
shall be
given. I
continued,
know.
and a date may be fixed after vacation.
Yes. Any objection to item 38? He doesn't want to get promoted. That case.
No, my lord. Actually, I took consent from the other side.
Okay, you've taken the consent. Okay, right. Adjournment prayer has been made by Mrs. K. Devi on the ground that she is not well.
Yes.
She also submits that she has taken the consent of the other side. I hope I don't see you in court, some other court to VC.
No, not like that. 38, my lord.
And accordingly, release this matter after the vacation, huh?
No, in
28, 29, and item 38, you say? Interim order to continue till the next day.
Immediately after opening. Actually, my lord, I'm going to Delhi for my second checkup. That's why.
So you're well. Yeah.
I'm not keeping well. Second checkup.
Why not a
You
similar
pick it for
pair?
38. Yes.
Why not similar pair for listing of motion on Thursday, 1 on 10?
Why not tomorrow?
Yes, well, tomorrow, yes, sir.
With the consent of the petition, item number 33, 34, 35, 36, and 37. That number will be taken up on 24th, my lord.
They are supposed to bring the records and file the affidavit.
Promotion to headmaster.
Yes, they have not done and
It
taken
is on
that for
24th,
several days.
Okay, right. On the prayer for adjournment made by Mr. S. Bora for the
For the PTC,
BTC. List the matter on
on
24th.
24th.
The matter pertains to promotion to the post of headmaster / headmistress, and in which the Mr. S. Bora was produced the record. You have delayed this matter, Mr. Counsel. 1 year you have not produced the record.
Yes.
Record has come, my lord. Before getting the paradise, the record has come. I have to extend it back.
Now where is it?
My lord, now it is come. Paradise comes to
It's come back.
It will come back, my lord.
Okay, list the matter on 20. Okay.
Item number 21.
31, yes.
Yes, sir. I'm for the private respondent.
Huh?
I'm for the private respondent. There will be some difficulty to match the details.
No, there is no difficulty here. It can be decided by the authority. It is a seniority issue.
My senior has
Who is the senior?
TJ Mahanta.
On the last day also same problem here. On the last 2 days. Give me this item 31. Cannot adjourn, carry on. Who's for the petition item 31? Yes. Yes. It was adjourned on your behalf on March also. Then 21 also. No adjournment. We take it up.
May I please, your lord? I'd like to mention item number 18, lord. Can I please speak on Friday, lord? Item 18. Yes,
Item 18. You are working as what? Are you working?
lord, yes, I am.
Working where? As what?
I just the subject teacher, lord.
Working as subject teacher.
Lord,
But you had been dropped.
lord.
You dropped when? Which year?
2000, under the Provincialization Act of 2017, lord.
You are provincialized.
Not
Not provincialized.
Non-inclusion.
You were dropped when? 2005, 6? When?
Lordship,
When were you dropped?
No, not 2017 and not 2000, in
We listen after the vacation.
2002
Friday to no one's there. Yeah,
after vacation.
after the vacation.
That may be fixed and 23rd.
Okay, right. On the prayer for adjournment made by the petition council, list the matter on give a date after the vacation.
23rd.
23rd. Right.
May it please your lordship. Lordship, I'd like to mention item number 22. Would like to withdraw this matter. We have filed the IA, would like to withdraw this matter, your lordship.
You want to withdraw the IA or the writ petition also?
Just only the IA. There is an inadvertent mistake.
Okay,
from our end, your
Miss
M. Zomonpui.
M. Zomanpui, learned counsel for the applicant, prays that she may be allowed to withdraw the application with liberty to file a fresh, because the name is there.
Yes, your lordship.
The prayer of the
Right.
applicant's counsel is allowed. The IA is dismissed as withdrawn, comma, with liberty as paid.
Okay. Second bit.
Miss P. Das appears for the secondary education department.
Great, please, your lordship. Lordship filed an IA yesterday. Lordship, the prayer is that the board has opened the portal online and it's closing today, my lord. It may be kindly taken up by two, my lords. Last year, the same problem has occurred, my lord, and by the order of this honorable court, we were able to onboard 51 students, my lord.
Why last minute you have come?
Lordship, we are unfortunate at the last moment we have come, but my lords, last year also 51 students were enrolled on the last day itself. At two, my lord,
When did you file this?
yesterday. Sir.
Okay, we'll see.
Okay,
It won't be at 2, last item.
last time.
Hello, item number 13 and 15.
13 and 15, yes.
Only pass with which time to file additional affidavit. I have to file additional affidavit.
Okay, right. Mr.
MH answer.
Mr. M.H. Ansari, learned. You see, Mr. Counsel, you have been given so much time, you don't have the documents it appears.
Date of the documents.
Mr. M.H. Ansari, learned counsel for the petitioner, is granted last chance to produce the engagement letters. Engagement slash appointment, engagement letters slash appointment orders. No further opportunity will be provided to the petitioner. List the matter after the vacation. No. They are in no hurry. They want time to look for the orders.
May my prayer is for this repetition. Motion matter, Lord.
No.
Against the service of the petitioner,
Tomorrow.
Lord.
Lord, I am praying for listing of a repetition of 2024. Similar case, Lordship has not disposed of. So my prayer,
What is the matter about?
the tutor's case, moral stakes, judgment is covered.
Tomorrow.
All right.
May I please your lordship, and for item number 10, kindly adjourn for,
Item 10.
yes, item 10, kindly adjourn for,
Item 10. Why?
yes, my senior, is incapacitated at the moment.
Please,
She's incapacitated at the moment.
give me item 10. What's your name, madam?
Bernali Chaudhary,
Barnali Chaudhary.
yes.
Right, Miss Barnali Chaudhary.
Not your state, or,
No, your name.
yes, Imsen Kala,
Miss Imsen Kala.
yes.
Spelling.
IMSENKAL.
Okay, Imsen Kala. Learned counsel appearing on behalf of Miss P. Chaudhary. Legal aid counsel. Pusa. The matter pertains to the the petitioner seeks to assail the order dated 30/01/2024 passed by the learned Assam Administrative and Pension Tribunal in case number 280/2020, by which the petitioner's appeal has been closed and the learned tribunal has refused to go into the merits of the case. Next part. The petitioner's case is that the leave salary for the period from 1 to 3 is here in the synopsis 1 to 3 has not been granted. So the petitioner is eligible to receive the sick. Don't say 1, 2, 3. Just say that the non-grant of leave salary, non-grant of leave salary. So the petitioner is eligible for. So many cases to suffer the leave. Next para. Issue notice returnable in 4 weeks. Who is for the secondary education?
I appeal.
Ms. P. Das accepts notice on their respondents number. One is Commissioner Secretary. Accept. Who is that? Commissioner.
Government, P. Saithya.
Huh?
P. Saithya.
P. Saikya accept notice on their respondent number 1. Then the Director of Secondary Education, Ms. P. Das. That is respondent number 2. Inspector of Schools, CDC. That'll be you.
Yes, sir.
Accept. 2 and 3. 2 and 3, Ms. P. Das. And finance, Ms. R.M. Barwa. R.M. Barwa accept notice on their respondent number 4. And headmaster, that will be notice.
Private.
Petitioner will take steps for service of notice upon the respondent number 5. By registered post with AD within 3 days. This is the matter after 4 weeks.
If the Lordship with the consent of others, Lordship, I beg to mention item number 3.
3.
Yes, Lordship.
Yes.
Kindly adjourn the matter for the debate. My senior
Why?
is out of petition hall.
What is your case?
Petitioner was terminated from his service, Lordship, due to
So, you're terminated from service
yes, Lord.
in the departmental inquiry, correct?
Yes, Lordship.
And thereafter, your departmental inquiry, you have been given compulsory retirement, correct?
Gentlemen, yes, Lord.
That has been reviewed,
Yes.
correct?
Yes.
Now you have been acquitted in the criminal case.
Yes, Lord.
Correct.
And that's also.
Now what remains? Just because you are acquitted does not mean that you become exonerated here. There's no.
Subsequently, we have filed an representation before the authority, Lordship, for
So
review.
what? They will decide whether they want
He's paying pension or provisional pension.
provisional pension. That they can decide. What is your right? Tell me. What is your right?
We take another day, Lordship. My senior.
Give me this item 3. The problem is, Mr. Counsel, we do the reading and we come prepared. At least in some cases. And you all, why should I allow? There's no case.
Then maybe withdraw with liberty, Lordship.
Liberty to what? Why?
File a review, Lordship.
File a review before the authority.
That's not fair.
That may be allowed. You can file. That is as per law, if it's allowed, you can do that, but not in this case. Right.
Withdraw, Lordship.
Huh?
Withdraw, Lordship, with that.
Because it is a covered matter. Covered matter means Supreme Court has given plethora of judgment. Even as far back as a latest 2021, where it says that just because a person has been acquitted in a criminal case does not ipso facto mean that he will be exonerated in a departmental procedure. There's nothing like that. Your case goes. Third, Mr.
MS Mondal.
M.S. Mondal.
Yes.
Learned counsel for the petitioner. Name here?
Yes.
Who submits that he would like to withdraw the writ petition with liberty to approach the appropriate authority for a review of the penalty of compulsory retirement. Ms. S. Kemprai appears for the point number 2 to 6. While Ms. S. P. appears for point number 1. The prayer of the petitioner's counsel is allowed. The writ petition is dismissed as withdrawn. Come out with liberty as faithful. As per rule. That's
Right.
entirely up to you whether you allow or do not allow. I can just say before that, it is however made clear that it is settled law that just because a person has been acquitted in a criminal case does not ipso facto mean that a person is to be exonerated in the departmental proceeding. That's all.
Mr. Lordship, I beg to mention for listing of the BPC 4901/2023 for orders after vacation. Any date, Lordship.
Go to the registry, madam.
In item number 14, madam, we not received
14.
40. Instruction is awaited.
Uh, 14, what do you want, madam?
Instruction is awaited, madam, after the.
It's a simple thing, madam. You just have to find out whether the DSC has considered the petition. Has it been considered?
Their instruction is awaited.
This is the first time it's coming. No, this is the
Second time.
second time. Okay, right. Miss S. Prithia, please for time to obtain instructions as to whether the DHC has considered the petitioner's case for provincialization. In terms of the order passed in WPC 7049/2020, which is at page 41 of the petition. Last chance is provided to Ms. S. Prithia to obtain instructions. Failing which the personal appearance of the director may be followed.
Because director has already communicated to the DO, madam.
Personal appearance of the DO person may be list the matter on 21.
It is not after.
First week of May, madam.
First week of May. Okay, list the matter on 1st or 5th. 21.
First, madam.
First.
Like-
First May. May Day.
May I please, Lordship? Lordship, with permission, I'd like to mention item number 11 and 12.
Yes.
Lordship, the council, A.K. Prokashta is now unwell since yesterday and he's suffering from fever. So the item will be kindly mentioned for the day.
11 I am at this.
Well, I am here.
Your writ petition at item 11 is woefully bereft of specifics.
Lordship, the submissions, will be better. He gives the submission because I'm not.
Okay, right. Adjournment prayer has been made on behalf of Mr. A.K. Prokashta, Learned Counsel for the petitioner. Miss P. Das, no, Miss A. Bhattacharjee, B. Bhattacharjee
I am appearing in
appears for respond number. You appear in?
Item 12.
Oh,
respondent
12.
number 5.
Okay, Miss P. Das appears
11.
for the secondary
Secondary.
education department. Huh? The challenge hearing is to the provincialization of the respondent number 5. List the matter after the vacation. Then item 12, the right heard mistake, adjournment prayer has been made on behalf of Mr. A.K. Prokashta on the ground that he is not well. Mr. D. Bhattacharjee appears for the respondent number 5, while Mr. S. Prithia appears for elementary education department. The petitioner herein is aggrieved with the denial of 5 years age relaxation. This is the matter after the vacation.
I gather, what I gather is perhaps AG has written to stay in this matter.
Huh?
What I gather from the petition is perhaps AG has written to stay in this matter.
Reduce.
No. We may have very little to stay in this matter. Well,
Madam,
anyway, let's.
Mr.
Yes, Hussain.
K. Hussain. Your name is not here.
Yes, my lord. My name is there.
Huh?
My name is there.
A. Hussain.
Yes.
Acha, Mr. A. Hussain, Learned Counsel for the petitioners submits that he has instructions to withdraw the writ petition. Ms. P. Das appears for the Secondary Education Department. The writ petition is accordingly dismissed as withdrawn. Acha, Mr. S. Bora for BTC, huh?
Oh, bless you.
Appears for BTC. Complied with
Complied.
Mr.
H. I. Chaudhary.
H.I. Chaudhary, learned counsel for the petitioner submit that the order dated 10/1/20, no, order dated order dated 23/5/23 passed in WPC 2683 of 23. 2683, huh? 2683 of 23 has been complied. Accordingly, the contempt petition, Ms. Pidas, PK Bora appears for sole responsibility. Accordingly, the contempt petition stands closed.
I want to withdraw only 42.
Huh?
42.
You have to withdraw 42.
42. 32 I will accept.
Okay.
42.
Okay. Mr. BP Bora, learned counsel for the petition, submits that he has instructions to withdraw. WP, why you want to withdraw?
But what has happened? Till provincialization, we are dropped from provincialization. Till provincialization, they give a financial assistance. Now, since we are in litigation, they have stopped our financial assistance. So we have no source of livelihood. We are forced to withdraw.
Okay. BP Bora, learned counsel for the petition, submits that he has instructions to withdraw the writ petition. Mr. S. Bora appears for the PTC, while Mr. S. Buya appears for Higher Education Department. On the pair of the counsel for the petitioner, the writ petition is dismissed as withdrawn.
Remaining cases, madam, from 43 to 47.
Yes.
Will be taken after this.
In the 43 to 43, right? These matters may be listed after the vacation.
This petition for not granting the scholarship.
Huh?
Not granting the scholarship, Lordship. University,
By the order dated 24/4/2024, I was directed to seek instructions from UGC as to whether the petitioner is eligible for the scholarship or not.
Yes.
In this particular matter, the petitioner is stating that she had applied for UGC Ishan Uday scholarship. But upon perusal and upon verifying from the records, it has been found that she has not applied for this UGC Ishan Uday scholarship. In fact, she has applied for post-matric scholarship to OBC students.
no.
And this particular instruction has been placed before this honorable court on 6/5/2024. The petitioner was also provided with a copy of the same. He was directed to seek instructions on the same and to convince this honorable court as to whether his case lies or not.
Okay, show me your application.
Lordship, that is not true, Lordship. That is the
You see, the problem is, Mr. Counsel. The problem is whether you have applied for this scholarship or that scholarship. Now, I cannot decide the matter on the basis of what you plead, what you say. It has to be there in the pleading with supporting document. Now, you have said that you have eaten an apple. He says, no, I gave him a banana. Now, who do I believe? There has to be some photograph evidence or something. Some.
Lordship,
I
Lordship,
have
kindly see Annexure 6.
the
Lordship, kindly see Annexure 6,
It is
6
there.
page 19, Lordship.
Huh?
Annexure 6, page 19, Lordship.
Annexure
The last Lordship,
page
number
19.
5, Lordship.
Page 19.
Yes, Lord.
Where
Annexure
Vidisha
6,
Nath.
Lordship, page 19, number 5, Lordship. Domicile certificate should be from the appropriate authority. This is the cause for the rejection, Lordship. But
Huh?
I could not be submitted the domicile certificate due to the non-issue of the domicile certificate from the Deputy Commissioner, Lordship.
Lordship, no, it is nowhere stated in this particular form
Yeah.
that
That should
he has
be clear,
applied
Lordship,
for
at first,
UGC
Lordship. Annexure 6,
Ishan Uday scheme.
page 19, Lordship.
It is nowhere.
Why don't you make a small affidavit? Then we'll
Lordship,
decide.
I have already produced the instruction. This is the application form.
Why, Lordship? Indrani Gogoi, Lordship, at serial number 5, Lordship.
Mr. Counsel, then I think you go to the civil court and decide. This is a disputed question of fact. I don't. There's no point shouting here. Doesn't change the thing. This court is only a court of law.
Yes. Yes.
Where questions of fact will have to be decided elsewhere. I cannot decide a case as to who is more handsome or who is taller or shorter. I have to decide on the basis of facts that are not disputed. Yes, where does it say? It's
Lordship, right at the top, it is underlined.
post-matric scholarship to OBC students. Sir.
Yes, Lordship. Yes, she has applied for this scheme instead of UGC Ishanuday scheme. So
Okay.
it's different scheme.
So has she been given under this scheme?
Lordship, this does not fall under UGC.
Okay,
This has been taken from the NSP portal.
Lordship, I have been annexed Lordship, annexed 5 Lordship. Kindly see Lordship at page 15 Lordship. Guideline for the Ishan Uday Special Scholarship Lordship. Under that guideline Lordship, I have been applied for.
Lordship,
They are saying that they are saying something else. You are saying that you have eaten puri today. She says that no, you have eaten toast. Who do I believe?
I have been rejected Lordship.
I will believe you, correct? Because you have said you are the one who ate. Now she is the one who is to receive the application. So she says, I have not received the application under this scheme, Ishan Uday.
Lordship, I may be allowed next day Lordship, I will be cleared.
Lordship, this is the 4th date.
No,
I will be
I'm
cleared.
disposing.
I will
You
take
go to
time.
civil court. You go, I'm giving you liberty, right? No point wasting time. Right. Heard, Mr.
Peace order.
G. Chaudhary, learned counsel for the petitioner. Also heard, Miss.
Dr. P. Agarwal.
Also heard Dr. P. Agarwal. The petitioner's case is that she is a student of class. She's a BA student.
Yes.
At B. Barwa College, Guwahati, for the session 2023-24. The petitioner had
Lordship, I may be allowed to withdraw Lordship. Kindly Lordship.
yes, okay, you are allowed to withdraw. No liberty. No liberty. If you want, I can say that you can go to the with liberty to go to the civil court. If you want that, that's all. No high court. Mr. D. Barwal, what do you want? What do you want
Be allowed to withdraw Lordship to file
to file? To
at High Court.
high court? High court, no.
From the
And then I'm disposing it. No. No. I'm dismissing it. Okay. Heard Mr. Spencer, learned counsel for the petitioner, who submits that the petitioner is a BA student at B. Barwa College, Guwahati, for the session 2023-2024. The petitioner's grievance is that the petitioner had applied for scholarship, for grant of scholarship under the Ishan Uday, ISHAN, Uday, UDAY, special scholarship scheme for Northeastern region under the University Grants Commission, New Delhi. However, the petitioner has not been given the benefits of the said scholarship scheme till date. Full stop. Next, Dr. P. Agarwal, the learned counsel for the UGC, submits that the petitioner, that the UGC have not received any application from the petitioner for grant of scholarship under the Ishan Uday Special Scholarship Scheme for the Northeastern region. He submits that. How did you get this?
Lordship, from the NSP portal. They had inquired from the
He
NSP.
submits that. Upon inquiry, the UGC have come to learn that the petitioner had applied for a post-matric scholarship from that is to be granted to OBC students of Assam from the National Scholarship Portal 2.0. The submissions made by the counsel for the party clearly show that they are disputed questions of fact, which require the recording of evidence. In view of the above fact, this court is not inclined to proceed with the present case any further. The writ petition is accordingly dismissed, with liberty being given to the petitioner to approach the civil court, which is given, if so advised.
If you please. Please, Your Lordship.
No, it's in there. But
I'm appearing on behalf of RB Freedom Election Court number 1. In this matter, updated instructions directly. Determining from Friday.
updated section of okay, heard Mr. B. Chakrabarti, Learned Counsel for the petitioner. Ms.
S. Bodo.
S. Boro,
On behalf of
appearing on behalf of Ms. R.B. Bora, Learned Counsel for the BTC, submits that instructions have not been received as to why the area salary of the petitioner has not been paid till date. Accordingly, please for time. Issue notice, returnable in 4 weeks. Ms. S. Boro accepts notice on behalf of the BTC, while Ms. R.M. Barwa accepts notice on behalf of
respondent 7, Your Lordship.
point number 7. This is the matter after 4 weeks to enable the BTC council to obtain instructions. Yes, what is your case?
Case is, my lord, for consideration of my case for old pension
Huh?
rule, my lord. Consideration of my case for old pension on the basis of a cabinet decision. And
What cabinet decision? Show me.
cabinet decision is that page number 131, my lord. It's not cabinet decision, it's a meeting, my lord. Decision has been taken up by the government, my lord, at 131 page number, my lord. At serial number 1, my lord.
The government of Assam will consider extending the benefits of the old pension scheme to those employees who join the government after January. But the recruitment process was started prior to. So, is there any notification issued pursuant to this cabinet meeting?
In this regard, my lord, we are appointed in 1993, my lord. Thereafter, Monoharan Commission has come up, my lord, and thereafter some regularization has been done. In this regularization, my lord, two set of batch were selected, my lord. One is access and another is 171.
You are appointed to government service.
Yes, my lord.
When? Where? Show me.
Our regularization is at my lord, at page number 76, my lord. And the list is annexed here with my lord. In earlier occasion, this matter was come up before your lordship, and your lordship told me to notice the petitioner's name and their.
Where is the petitioner's name?
My lord, I have shortlisted it.
No, why isn't it
No, no.
here?
No, I have made it, my lord. That page number, my lord, it's from 81, my lord. Petitioner number 1 is at serial number 20, my lord.
No, let us see. What does the order say?
My lord.
Where is the order?
Order from 76, my lord.
76 is a different order.
My lord.
Then 79 is a different order. Is it?
79 is the list, my lord.
79 is a
79 is, 79 is the original one, my lord. 76 is the type copy, my lord.
No, Mr. Counselor, tell me one thing. This page 131.
Right.
Where is the government notification
There is,
implementing this cabinet decision?
thereafter, what happened, my lord? Thereafter, my lord, on the basis of this decision, my lord, a writ appeal, a set of writ appeal has been disposed of. And thereafter, my lord, some process has been initiated by the government. And in that process, my lord, some of the employees, teachers, whose services were regularized along with the present petitioners on the same list I have annexed in this petition, my lord. Their cases are processed, my lord. But
Where is it? Process means what? Has it come to an end, the process?
no,
or is it
no, that is continuing. And as per
continuing?
our instruction, my lord, the file is in finance department, my lord. So I only prayed for consideration of our case also on the basis of this.
No,
case.
show me where it is being considered. Whose cases are being considered?
My lord, that is that page number, my lord, in whose, in this regard, my lord, there are two set of writ petition, my lord. In first set of writ petition, my lord, from that 117 page, my lord, 9 numbers of candidates approach before this honorable court earlier. On that writ petition, my lord, this honorable court has directed to bring them under the old pension rule. That order is there in, my lord, page number 104, my lord.
Mr. Counsel, it's a small thing. You said that similarly placed persons' cases are being considered. Who are those persons?
My lord, those persons are, my lord, page number 104, my lord, that their services already been taken up under the old pension rule, my lord. This is the order, my lord, passed by this honorable court in earlier round of litigation. And those persons are, my lord, I have picked up the list, man, from the list, my lord, which I've here annexed.
Sorry. Who are those persons? I don't know. Have you made any pleadings to that effect? Where? Show me. The names are there.
That's page number 19. Paragraph 30.
Where?
That the petitioner begs to state that in the meantime, out of 117 numbers.
No, who are those names? Don't
Lord,
give me that.
in this matter, my lord, may fix this matter, and after the petition, my lord, I'll find an additional affidavit bringing all the names of those persons and their serial number in the provincialization list, my regularization list, my lord. Where is our name of there after the vacation, my lord. I'll find an additional affidavit bringing all the name of those
Right. Heard, Mr.
MAI Hussain.
MAI Hussain, Learned Counsel for the petitioner. To submit that the petitioners are similarly situated as some persons amongst the 117 school teachers of Nagaon district proposed to be regularized by the government. And as such, their cases also should be considered for regularization. Is it? For regularization. However, the petitioner has not specified as to who are those persons whose names are proposed to be regularized by the government.
No, my lord, our services have been regularized.
Okay.
So
Not regularized, who are to be given, who are to be governed by the
old pension
Assam Service Pension Rules 1969. As such, the petitioners should also be governed by the 1969 rule. Okay. Here and after referred to, you mentioned after. Super. Next para. The petitioners claim for being governed by the 1969 rule is the minutes of the meeting held on 15/3/2024 under the chairmanship of the Honorable Chief Minister Assam, page 131. Wherein it was stated that the government of Assam will consider extending the benefits of the old pension scheme to those employees who joined government service after January 2005, but the recruitment process for the concerned post was started prior to January 2005, in line with the recent OM issued by the central government. This page 131. Next, the petitioner has not been able to show this court as to whether any notification has been issued pursuant to the meeting minutes dated 15/3/22. Accordingly, as the petitioner takes time to file an additional affidavit to bring on record the names of those persons who are similarly situated as the petitioners who are governed by the 1969 rule, and to bring on record the notification made pursuant to the minutes of the meeting held on 15/3/2024. This is the matter after the vacation.
Yes, Lord. My lord, pursuant to this honorable court order, my lord, I will file an appeal before the government, my lord, and which is pending. Now, my lord, I am seeking a direction to dispose of my appeal with the time bound. Page 39 is the order, my lord,
Page 39.
of the order of this court. Earlier, I filed a filed with petition. And my lord, relevant part, page 43. 43 is the direct. My lord, page 45. My
So basically, you want to be provincialized as a social
lord,
studies teacher.
my lord,
Social studies or social science?
social study, no, social science,
Social science.
social science. Now on page 45, government has initiated a process already, my appeal, and it was directed to the Director of University Education, submitted to
Okay, right. Heard Mr.
M. Ali.
M. Ali, learned counsel for the petition. Also heard Ms. N. Fukan, learned standing counsel of the Elementary Education Department. The petitioner grievance is that the state respondents, while provincializing the services of the teaching staff of the Otar Baguri Bari two classes.
Private
No, huh?
respondent here, my lord.
Huh?
Respondent number 4 is a private respondent.
Not required, my lord. Government will decide my appeal. It is
They
already,
have not also annexed the appeal, my lord.
Huh?
They have not annexed the appeal.
But this letter is there at
Yes,
page
ma'am.
13,
Only this
page
letter.
45. Huh?
Yes, ma'am.
Then?
No, my lord. Respondent number 4.
my lord, government will also hear the respondent. And it is already
Yeah,
already
yeah.
directed.
Whatever I said. Teaching staff of Uttar Baguri Bari, two classes. What school name is this?
ME school, Uttar Boguriwari ME school.
Uttar Baguri Bari ME school. Comma. The petitioner's service was not provincial. The petitioner, who claims to be a social science teacher, accordingly
Para 3,
filed WPC 1724/2022, saying that her service should be regularized in terms of the 2017 Act. Next paragraph. This court, while disposing of WPC 1724 of 2020, by order dated 6/2/2020, had directed the petitioner to prefer a statutory appeal before the Secretary to the Government of Assam in the Department of School Elementary Education as provided under Section 14 of the 2017 Act as amended, to be decided by the authority. It also held that this court also held that in the event of the petitioner filing the appeal, the Secretary to the Government of Assam in the Department of School Elementary Education, on verification of the relevant records, was to dispose of the appeal within 90 days. And after giving an opportunity of hearing to the petitioner, the petitioner's counsel submits that in pursuance to the order dated 6/2/23 past it, WPC 1724 of 2020, the petitioner has filed an appeal under Section 14 of the 2017 Act to the
Secretary,
Secretary to the Government of Assam, Department of School Education,
my lord.
on
On 6/6/2023.
6/6/2020. The petitioner's counsel submits that the petitioner's counsel submits that the Deputy Secretary to the Government of Assam, Department of School Education, has filed letter number E-301887/67 dated 20/06/23. Sent a letter. No, right letter is to the Director of requested the Director of Elementary Education, Assam, to submit a report on the appeal submitted by the petitioner for taking further necessary action on them. However, the petitioner's petitioner's appeal has not been decided till the petitioner's counsel submits that the writ petition can be disposed of. Why don't you file a contempt? Same order.
This is time bar.
Petitioner's counsel submits that the present writ petition can be disposed of if a direction is issued to the Director of Elementary Education to submit a report to the Secretary to the Government of Assam, Elementary Education Department, Department of School Education, to submit a report with regard to the appeal filed by the petitioner. And to direct the Secretary to the Government of Assam to take a final decision on the appeal filed by the petitioner. Ms. N. Pokan, Learner Counsel for the Elementary Education Department, submits that she has got no objection to the prayer made by the petitioner. Ms. Park. I have heard the Learner Counsel for the no, then this paragraph 14 and 15 of the order dated 6/2/2020, passed in WPC 1724 of 2020, is reproduced herein below as follows. That is at page 43. Next up. The letter dated 20/06/23 issued by the Deputy Secretary to the Government of Assam from a Department of School Education to the Director of Elementary Education. Says as follows. Page 45. Read to them.
Para 17 also.
Huh?
Para 17 also.
Okay. Para
Para-
14, 15, 16, 17. Right? Okay. You make it 18 or how does it matter? 18. Huh? Then this is page 45. Next part. On a perusal of the above order passed by this court and the letter dated 20/06/2023 clearly goes to show that the Secretary to the Government of Assam, Department of School Education, was to take a decision on the petitioner's appeal under section 14 of the 2017 after receiving a report on the matter from the Director of Elementary Education. As the same has not been done, the Director of Elementary Education Assam is directed to submit a report to the Deputy Secretary to the Government of Assam, Department of School Education, in relation to the letter number E-301887/67 dated 20/06/23 within a period of 1 month from the date of receipt of a copy of this order, along with a copy of the appeal made under sections 14 of the 2017 Act and a copy of the writ petition. Thereafter, the Secretary to the Government of Assam, Department of School Education is given will take a decision on the petitioner's appeal within a further period of 1 month. The writ petition is accordingly disposed.
There are some subsequent development methods. 127/3/2025 that
Huh?
127/3/2025. The NCT has issued show cause. Now the governing body is dealing with the show cause. But ultimately, method it will go on. So I may be able to withdraw method liberty.
Mr. S. Clerk counsel for the petitioner says that he may be allowed to withdraw the writ petition and with liberty to file a fresh, in as much as a show cause notice has been issued to the school management committee by the
NCT.
NCT
127/3/2025.
NCT on 27/3/2025. Mr. B. PJ Fugan appears for what university? And I alum appears for NCT. Anybody else? Mr. P. Saikya appears for the prayer of the petitioner's counsel is allowed. Writ petition dismissed as withdrawn. With liberty as written.
What time of it?
Well, the consent petition, order dated, violation of order dated, non-compliance of order dated 9/10/2023. Operative parties at page 14.
Is the period over?
Over. No, 1 year not over.
Why not?
Kindly see, my lord.
Order is of 9/10/23.
Yes, my lord. There were some time given, my lord, 1 month, 3 months, 3 months time.
Let us see the order.
My lord, page 14, my lord. May I read, my lord?
Period of 1 month.
No, my lord, 1 month, sir, this left.
2 months.
May I read, my lord?
Yes.
Considering the above submissions and upon perusal of materials available on record, the provincialization of respondent number 5 by order dated 4/2/2021 is found to have been made on the basis of his joining in the school, that is 16/12/2002, which otherwise does not have any support from the materials available on record, and therefore the same is found to be unsustainable. Accordingly, the same is hereby set aside. The respondent number 2 is directed to place the
So
name of
basically giving 3 months time. 3 months.
3 months.
So 3 months, and when did you give this order to them?
My lord, I have submitted this on, but you will find that page 17/10/2023.
17/10.
Yes.
And 17/10, 3 months will be over when? 17/1/23, 24.
And we have
And
filed
1 year will be over when?
1 year will be over, my lord. I have filed it on, my lord, 10th of January. So before elapse
10th of January.
but this may kindly the page 10.
Okay. Yeah. Right. Heard, Mr. N.K. Kalita, another counsel for the petitioner, who submit that the order dated 9/10/23 passed in WPC 4226/21, and the order dated 16/10/23 passed in IA 3172/20 has not been complied with. So now, for considering provincialization of the petitioner has not been complied with. Issue notice returnable in 4 weeks. Mr. Now, the petitioner shall take steps for service of notice upon the respondent by a registered post with AD within 3 days. This is the matter of the post.
All right.
May I please, your lordship? Lordship, and draw lordship's attention to page 107 of this writ petition.
Yes.
107. Lordship, prior to filing this particular present writ petition, the petitioner approached the honorable court and writ petition was filed number 3518/2021. In that particular writ petition, say writ petition was
So
disposed.
you submitted a representation. What happened? Nothing was done.
Nothing happened. Then we
File another writ.
contempt. Contempt was disposed with the relevant para herein is
Okay, right. Mr.
T.R. Sen law.
P.R. Sen, the counsel for the petitioner submits that the petitioner has not been paid his arrear salary despite the closure of the contempt case number 748 of 2022, right order dated 4/10/2023. On the basis of the
Para 4 of that.
on the base on the basis of the Director of Secondary Education, SM, no. On the basis of, no. On the basis of a direction issued to the Director of Secondary Education, SM, to pass a reasoned order on the petitioner's representation for payment of arrear salary. However, the same has not been done till date. Issue notice, returnable in 4 weeks. Ms. P. Das accepts notice on behalf of
1, 3 and
1, 3 and 4. Ms. R. M. Barua appears for point number 2. This is the matter of the 4 weeks, been able to obtain instructions as to why arrear salary has not been paid to the petitioner.
deeply obliged.
Extra copy may serve upon.
Extra copies of the petition be provided to Ms. P. Das. They are in the cost of the.
Deeply obliged.
Yes, heard, Mr.
Deeply obliged.
No. Next. Mr.
AK, that's what.
Huh?
AK, that's what.
Heard, Mr. A.K. Das, then I talk about the petition. To submit that the that the service of the petitioner was to be provincialized in terms of the order dated 20/12/24, passed in WPC 3723 of 24. Issue notice, returnable in 4 weeks. Kept within 3 days. Huh? Basic. 15.
This item may take after some time, Lordship.
Why?
Senior consider decision another court.
Here the petitioner had participated for the post of assistant professor in under the Assam Agriculture University. Lordship should find at page 49 is my PhD.
So in passing of timely, you will appear.
I think can be done today. And there is no question of stay or something. It's only a question of notice. Yes,
Then Lordship would find the advertisement at page 115. Where Lordship should see my post.
115. Yes.
115 it starts. My post Lordship should find on the next page, at page 117, serial number 5.
Yes.
Which, then Lordship should find
Here for which one? Faculty of Fishery Science.
the fishery resources management. Ani? Fisheries
Okay.
resources management.
Yeah.
Then Lordship should find it page 118. The essential
Yeah.
qualifications are given 1, 2, and 3. I satisfy all the eligibility conditions.
Which the top.
Page 118, the top one. There are 2 given. The below one is for agriculture statistics, above and for other than agriculture.
Yeah.
3 are given. I fulfill all 3. Then Lordship should find in my application at page 120 how the marks are supposed to be given. Lordship will find how the API is calculated. On the 4th point, Lordship will find A04,
Yes.
PhD degree, percentage of marks, CGPA 10 scale, maximum marks allocated would be 10. Now, when I make my application at page 126, my application starts, and at page 125, I'm sorry, page 126, Lordship will find this is my marks which I should have got. A04, Assam Agriculture University, 2023, I passed my PhD. I secured 88.5, so my marks given for my PhD should be 8.85. Lordship. This is how we calculate it while applying. So this is 8.85 I should have scored. And on the next page, Lordship will find for the column A, the total marks that I would have scored is 41.42.
41.42.
42 is the total I should have scored in group A. The marks which are given in group A, that is for my higher secondary council, my bachelor's degree, my master's degree, and my PhD, along with the experience, if any. All these total up to 41.42. What you find?
So what is wrong?
Now, what happens is when they give the appointment, when they calculate my marks, Lordship will kindly have the last page of the repetition at page 148.
Yeah.
I am at number 2, Lordship finds. I'm the person number 2. For column A, they give me 32.57. Now, this 32.57 plus 8.8 for my PhD would have made it 41.42. So they miss out my marks on my PhD, thus bringing me down from with the other candidates, 3 of them being appointed. I miss it out. If I get this 8.85 on my PhD, I score above everybody else. I was the first person to have been appointed.
Others don't have PhD.
They have PhD, their marks have been taken. My
Actually, out
PhD,
here in this
my
page,
marks have not been calculated while
so
doing
that means your marks would have been 40 plus,
41.42.
be highest.
Yes, that is the case. At this stage, let him have his instructions, no difficulty. That post which I should have got was not filled up. There is another advertisement which came up
That
after
post
I
was
filed
not
my-
filled up. Let us see that
again.
page.
Lordship should have the advertisement is page
117.
115. At page 117 is how the marks are to be calculated. I'm
No,
sorry,
no,
ma'am.
117
Page
is the
120.
Now out here, you have gone only for fishery resource management.
Yes,
correct?
ma'am. I went for fishery resource management. Now, what they have done is, after the filing of the petition, they have issued an advertisement on 31/3, advertising the same post again.
It has
My only
it has
prayer-
not been filled up.
It has not been filled up. My only prayer is till they come up with the instructions, whether the PhD marks are given or not, let them not fill it. I'm not disturbing.
That is a
anybody.
new advertisement.
Yes, I have, but yet.
That is not a part of the writ petition.
That is not because after I filed the repetition, this advertisement came into. The notice being issued first.
Then they have got to file an additional affidavit.
I'll file it on additional, but only I'm asking, let them not fill it up without the leave of the court. By the meantime, I'll bring it on the record, I'll get a.
Well, let him appear before that advertisement.
That
There
is
are
not
other
the issue.
advertisement we are cancelling, that we are not going to. This press advertisement, there's no bar in it participating.
People have.
No,
have been
no, but
appointed.
then if he has
No,
got
but
a-
what has happened, he has appeared for FRM, Fishery Resource Management.
Correct.
But the other appointments is sailing are several different disciplines, my lord.
It is on the same thing. I would have scored above them. I would have come in. Same
With that case,
department.
my lord, they have been participated for the same post. That could I have understand, my lord. Lordship will kindly come to,
they participated for same post.
no.
So he should, so why is he not given? If there is, why is he being denied this post of fisheries resource management? If there's no takers for it,
my lord will kindly
the
come to
pocket
page-
is marked, pocket is
my lord
marked.
will kindly come to 124.
124. Yes,
This is the application, madam. He is on the second page, next page, madam. He is, the discipline is mentioned FRM, Fishery Resource Management. Page 120,
125.
120. Fishery Resource Management, discipline is mentioned there.
Yes, so what is wrong?
I'm just trying to demonstrate something else. Madam. And then my lord will come to page 140.
This, okay,
Discipline
140.
again, minus 140. Discipline is again Fishery Resource Management. He's competing against Kobin Medhi. Two.
Ah,
One
140.
and two. There are two participants, madam. Kobin Medhi. Fishery Resource Management, page 140.
One,
Yes, shortlist. Fishery Resource Management.
there is only one, Abdul Malik.
No, madam. Serial number 2.
Kabir Mehdi.
Kobin Medhi is there.
So he was not there, you mean?
Now my will come to page 140.
141.
Against the disciplines which are these two private respondents are my lords appointed. It's not Fishery Resource Management, madam. I don't understand why they're bringing them there.
No, I'm not understanding your line of.
Say, madam, why they're
submission.
bringing in, why, but the question is, my lord, why he's bringing in these two other private respondents,
As parties.
whereas their disciplines are different.
I'll explain that, madam, how it happens. Lordship should have the advertisement at page 117. How did we? Acquaintance with the appointments in universities is important. Page 117, Lordship will have serial number 5. Lordship has it.
Yes,
There is one department which is called the Faculty of Fisheries. Then Lordship will have on the immediate next column, it is Aquatic Animal Health and Management, one person will be taken in. Fishery Resource Management, another person will be taken in. And third, Aquaculture, the third man will. These are the 3 posts. Then to extreme Lordship's right side, Lordship will find Reservation, Assistant Professor, total number of posts 3, unreserved 2, reserved for women 1 and OBC 1. What happens is this. 3 posts are given to a particular department. They choose what subjects teachers to be taken. Now, when the interviews are held and the marks are taken up, all the candidates are sorted out. The top candidates, whichever subject they had applied for, are the subjects which get filled up. Am I being able to my
no, one thing I want to know, out here it says 3 posts,
Yes,
unreserved 2.
unreserved 2.
Now, which is the reserved category?
That is one part which will come up once those are grounds taken in the repetition. I was not troubling Lordship. David. They have not appointed a woman against any of the posts which they have filled up. Why this happened is this. That is what I'm trying to emphasize.
all candidates will apply for all the three. Any and all candidates in that particular department, all are called. The total of marks are taken. Merit list is made. The first 5 get in wherever they had applied.
But there are only 3 posts.
So now that is one matter. Suppose 15 people apply. Now we do not know how many will apply in aquaculture. We do not know how many will apply in fishery resources. We do not know how many will apply in aquatic. Total 15 persons apply. Only their total marks will be taken in the merit list. In that merit list, the toppers will be given the options of appointment. Therefore, my argument was, had my numbers in the PhD been taken, I would have been in the top of the list. The first post to be filled up would be fishery resource manager. What they did was taken out my marks. These other 2 people who have been appointed, they were shown to be above me in the merit list. Their posts are being filled up.
No, but one thing is, out of 3 posts, which is for the OBC, which is for the unreserved.
Nothing given. Those are things which will come up when we argue the writ petition in its totality. As of today, what I'm trying to show is my merit position being at number 1. If I had been placed at number 1, the fishery resource management would be the first post to be filled up. Therefore, the other 2 private respondents would go down below in the merit list.
Anyway,
Perhaps not filled up.
as on date, it is not filled up.
It is not filled up, so they will not fill up with the code is all I'm paying for.
If it's not filled up, why didn't you fill it up? He was there for that fishery resource management.
My lord, I think admittedly there's one lapse on our part because when we declare the results, his result was not communicated to him because he writes in page 143.
143. 143.
That is the whole premise of this petition, my lord. 143.
143. Yes.
Yes, Lord, people see the subject.
143. Yes.
It's the
143 is a letter.
My letter, my lord. He is written to the registrar that
Yeah.
he wants to know what happened to his. What happened? What is the fate of the participant for that process?
Yes.
Exactly. Again, he's writing, my lord. He writes again that FRM. Again, he mentions FRM.
Yes.
Maybe because of the other persons appointed and his fate was not made known to him. That is the anxiety perhaps the petitioner
You
suffers.
see, the simple question right now he has put is that in this page 120 is it?
Yes, madam. 120. 120 is where I calculated. 120 is the marks to be given on different topics.
And where is the mark?
A4 is where I should have the total marks given is 10.
Where is that page?
Page 120, Lordship will find A04.
No. Page
And-
148.
Yes, page
Page
148.
148. Have you got 148, Mr. Gogoi?
Well, yes.
This number 2, he says this
Zero.
32.57 has to include that PhD marks of 8.85.
8.8. They total it up, I get.
So is that correct? That's the only issue.
My lord, that I will take instruction, my lord. Short date may be given, no stay, my lord. That advertisement, Lordship will not, no, my lord, will not grant me that all.
No.
Lordship will not pass
We'll
that order
fill it up and
without
come
giving
back
the,
then.
my lord. Because Lordship will see if the appointment they are selling of Avinash Talukdar, he has also got 0 in column B.
That is his experience. He's got 0 in
May
experience.
apply before 4 p.m. of 30/04/25. There is some time. There is
The
some-
Lordship will observe that the interim is not being considered because
Yeah.
of the length. Otherwise,
Correct.
it will be considered if it did not come up with.
That will definitely come, my lord.
The right, Mr. R. Mazumdar, learned counsel for the petition, who submits that pursuant to the advertisement dated 11/12/2020. Pursuant to the advertisement dated 11/12/2023. Pursuant to the advertisement number 8/2023, 8/2023, dated 11/12/2023. The petitioner applied for the post of assistant professor in fisheries resource management. When the marks were when the marks of the candidate were put in a comparative chart, page 148, bracket. The petitioner was shown to have secured 32.57
In column A. no.
in
The other-
column A. The petitioner's counsel submits that the petitioner is supposed to be given 8.85 mark for his PhD against column
A, column A.
against column A also. Thus, by adding the 2 marks, the petitioner would have secured the highest mark and would have been allotted the post of assistant professor, fisheries resource manager. However, the same is not there. Mr. B over, no. D. Over. Learned counsel for the Assam Agriculture University. Submits that he will obtain instructions as to whether the marks obtained by the petitioner in column A, that is 32.57, includes the mark that the petitioner was to be given for his PhD. Next paragraph. It is the petitioner's counsel submits that the post of assistant professor fisheries resource management that had been advertised in the advertisement number 8 of 2020 has not been filled up. And the same has subsequently been again, and the said post has subsequently been again advertised by advertisement number 3 of 2025, dated 31/3/2020. He prays that there should be a stay of the advertisement dated 3 of 2025, insofar as it relates to the post of assistant professor fisheries resource manager. Next slide. This court finds that the advertisement number 3 of 20, finds that the last date of submission of application pursuant to the advertisement number 3 of 2025, dated 31/3/2025, is 30/04/2025. Next slide. Accordingly, this court is of the view that the issue of whether an interim order should be passed will should be decided at a later stage, keeping in view the prayer of Mr. D. Gogoi that he will obtain instructions and submit the same on which date? Give a date. 24. 24. 24. 24. 24. List the matter on 24.
I take liberty to renew my prayer for.
Huh?
I'll be at liberty to renew my prayer for interim on 24.
For?
To renew my prayer for interim on 24.
The prayer of the petitioner for grant of interim order may be decided on the next day.
I'm obliged.
All right.
I'm sorry, Lordship. I have to mention, Lordship. Item 36, they have taken adjournment without consent.
Item
36, they have taken adjournment without consent. Also, there is an interim order.
36, 37. Okay. Interim order is there.
Interim order is that.
It's 36. Okay, this is just the interim order to continue with WPC. Item 19.
Small issue, parents. Still teacher, allow the still obtain degree of the PhD. Now, person who joined service prior to 3/7/2012 and obtained BA degree after that, and only entitled to one degree, one given minor. And Similar order is also there, my lord, page 55.
Yes, but where is the civil order?
Yes, my lord, page 55, sir. Page 55. There's the reason portion.
You are serving where?
I am serving, my lord. State teacher, Dondor Soria Higher Secondary School, Rota. All schools covered. High school, higher secondary.
Okay, right. So we'll dispose of. Right, Mr. Yes, Chauhan.
So the eight-
Hey, Chauhan. Let us cause for the petition who submits that the petitioner is presently serving as a postgraduate teacher,
No, my lord,
As a-
serving as assistant teacher
as an assistant teacher
in Dondor Soria Higher Secondary.
in Dando Shaharia Higher Secondary School, Rauta, Udalguri. The petitioner whose case is that he is entitled to an advance increment as he has acquired a B.Ed degree from a university grant commission, from a university recognized by the University Grants Commission. Is it?
Yes, ma'am.
Or NCT, which one?
My lord, then her certificate is page 6, my lord. There is,
Page 6. From where?
that is, is two, my lord. NCT
And
recognition.
and college approved by the National Council for Teachers Education, bracket NCT. He submits, the petition council submits that as the petitioner has acquired a B.Ed degree, the petitioner is entitled to an advance increment in terms of the office memorandum dated 7/3/1998. Correct?
My lord.
He accordingly prays that the respondent authority should verify the claim of the petition. And if it is found that the petitioner is entitled to the advance increment in terms of the OM dated 7/3/1998, the same should be granted to the petitioner. Mr. R.K. Mushahari, Learned Counsel for the PTC, and Mr. U. Sharma for the point number 1 and 2 submit that they have got no objection to the prayer made by the petitioner. Next part. In view of the consent of the party, the who is to verify?
Only one more voting still there, my lord.
Okay.
Yes, page 44, my lord. Annexure 5.
40.
Page 44, Annexure 5. This is a subsequent order, by the 21 July 2016.
Okay. But this OM also 7/3/18
Yes,
also.
yes.
Okay, so we say two OMs. Nah?
Yes.
So you say OM dated 7/5/1990 and notification dated. No, and letter dated. What is it?
Right.
Huh?
Office letter.
How is this relevant to this case?
Because, my lord, because this is regarding employer, subsequently there are some dispute, my lord. So ultimately, this 21 July 2016 notification came, man. That is also
This is not a notification, this is a letter.
a letter here. This letter indicates, my lord. Following that,
Okay. Notification, OM dated also, and letter dated 21/7/2016, issued by the inspector of, issued by the,
It is the joint secretary, to secretary education.
issued by the joint secretary to the government of Assam, secondary education department. Wherever that is. So whatever I said at the before. About this, who is to decide?
Yes, but the respondent number 2 will speak up.
That's point number 2 and 3 are to take a decision as to whether the petitioner is entitled to an advance increment in terms of the OM dated 7/3/1998 and the letter dated 21/7/2016 issued by the Joint Secretary to the Government of Assam, Secondary Education. Joint Director,
Yes, yes.
Joint Director,
Sure.
Joint Director of Secondary Education, not Joint Secretary. The entire exercise should be completed within a period of 3 months from the date of receipt of a certified copy of the order, along with a copy of the writ petition. The writ petition is accordingly disposed.
Comment.
But, matter of degree, apart from for timing, first, Mr. Secretary,
Yeah, please, your lordship.
So you want the gradation list to be prepared
Yes.
of assistant teachers. That's your, no,
Yes.
that's all. Right. This is item 21. Mr. Yes, your name,
R. Besborough.
Mr. R. Besborough, Learner Counsel for the petition. Please, submit that. No gradation list of assistant teachers has been made for making regular appointments to the post of head clerk. We accordingly submit that gradation list should be prepared by the respondent. If you notice, returnable in 4 weeks, Mr. MK. RK. Mutari, accept notice on behalf of 1, 2, 3, 4. 1, 2, 3. While Ms. N. Cooper, accept notice on behalf of policy number 5. You 1, 2, 3, 4, I think. 1, 2, 3, 4. 1, 2, 3. Yeah, fine. Petitioner will take that for service of notice upon the respondent number 5 to 8. No, 6 to 8. By registered post with daily visit. 3 days. List the matter for you. Where is the SSA?
Name shown today.
SSA, I did the SSA council. Right. Right, Mr. A.M. Barbuya, Senate Counsel for the petitioner. Who appears for the others? Elementary education? Mr. Ipetu appears for the elementary education department. Who appears for secretary, commissioner secretary, school education? You appear? Okay, so he appears for 1, 2, and 4,
but I appear for 3 and 5.
3 and 5. Mr. S. Bora appears for respondent number 3 and 5. So your case is
dice code was my lord period, but subsequent it is not my lord updated.
Not seen.
Yes.
Not seen in the website. So you are asking for a password.
Password my lord and consider someone because on as per law my lord if dice code is not there, it is not full at all.
What, can they give you the password? If they give you the password, then you will change the entire website. There is a question of giving you password.
Not necessary, my lord, only my lord.
Let us see a prayer in the writ petition. What is your prayer?
No, I am not praying password in the register.
Huh?
Yes, my lord, prayer.
Commanding the response to okay. Yes.
I will get it.
Okay, issue notice. Okay, right. Huh. Whatever, sir. The matter pertains to. No, the case of the petitioner is that though a dice code had been earlier allotted to the school, the same had not been updated in the website. The petitioner thus prays that. No, that's right. Though the petitioner, in his representation to the mission director SSC, has asked for issuance of a new password so that the APAR double A, huh, ID could be generated. The petitioner in his in his prayer has prayed that the respondent should restore that update the the diet code of the school. Issue notice returnable in 4 weeks. Mr. No, as the counsel for the respondents have accepted notice, no formal notice be issued. This is the matter after 4 weeks to enable the respondents to obtain it. Keep going.
Maybe. My lord, it is for completing what is responded, what you will find page 7, prayer portion. The respondent number 11, which we added as respondent number 12.
11A.
Assam Sarva Sikha Abhijan Mission. Page,
Okay, right.
page
Alright.
4.
Mr. Why 11A? He's already there. He's already a party. He's not a party.
He is not a party. Somehow it was missed out. Huh? So we have fine.
Alright. Mr. M.U. Mandal, learned faster for the petitioners. Applicants who submit. The applicant who submit. Who is Mokram Ali?
The petitioner.
Who submit that the Assam Sarba Shiksha Abhijan Mission bracket SSA Assam, represented by the mission director, SSA, Assam, Kahili Para, Guwahati -90, should be treated as respondent number 12. Mr. G. Pegu appearing for the for the elementary education department, and Mr. P. Sakia for the respondents number 1 and 4 submit that. They have got no objection to the application being on. So submit the above. So and so is that respondent number 2. Applicant is to submit the corrected copy of the cost title to the registry within 3 days. I accordingly allowed and disposed. Then in the main case, right? In view of the order dated 8/4/2025, passed in highest civil number 1132 of 2025, the SSA inferior as respondent number 12. Issue notice to the respondent number 12. Mr. S. Bora. S. Bora accepts notice on behalf of respondent number 12. Extra copies of the writ petition be provided to Mr. S. Bora during the course of the. This is the matter after 4 weeks to enable the respondent to file the affidavit. Right.
I'm being added 20.
You are working as what?
We are working as the teachers and grade 4 employees of their manner. They are getting the salary of minimum scale of pay at the rate of 2010 ROP. But
What is your prayer in the writ petition?
enhancement of the malad at the rate of enhancement of salary at the rate of malad ROP 2017. It is given as per old ROP.
Okay, right. Heard Mr. P. Prakasa, Leonard office for the petitioners who submit that the petitioners are being given the minimum pay scale grant, minimum pay scale in terms of the ROP 2010 instead of the ROP 2017. Issue notice returnable in 4 weeks. Mr. T. Sharma accepts notice on behalf of
Number 3 and 4.
3 and 4. Mr. U. Sharma for 1 and 2. Ms. R. M. Barua for 8. While Mr. P. Saikia for 6. Who is appearing for 7?
But if 7, Mr. Mr. R.R. Kaushik will appear, but he is not present today. Having his father's passport. On behalf of for 5 and 7, give it.
Huh?
For response number 5 and 7, give it.
I will 7. So who do how long?
But if is
Okay, right. No one appears for the response number 5 is set. Petitioner will take steps for service of notice by registered post with any upon.
there is sending out.
Huh?
There is a sending out.
Who? Where is he?
But if he has not come today, my lord.
Then what to do?
Then his name may be recorded with the provide.
Okay, Mr. KK Kaushik. K. What is his name?
That's Kaushik, R.R. Kaushik.
Mr. R.R. Kaushik except as Mr. R.R. Kaushik, who is the standing counsel for the
Response number 5 and 7.
response number 5 and 7 is not present. Today, Mr. P. Prakasa shall furnish copies of the extra copies of the writ petition to Mr. R.R. Kaushik within 2 days. This is the matter after 4 weeks to enable the respondents to file their
Offline. In this matter, I have some time, I have to take inspection whether he is interested or not, because my friend has inspected me that he has already appointed him some other.
Oh, that.
Then
We take it by 2, we take it by 2. Just phone him up, no point wasting time. You phone him up at 2 o'clock.
after verification, because
You call him up, you
No.
just,
my phone number is not available, but because in this tomorrow I will perhaps get my learner friend will arrange the number.
Huh?
By tomorrow, I'll get the.
he has the number of your client.
No. I have some other similar person will you collect.
You don't have any idea where your client is.
No, I have the idea, but I have no communication.
Mister,
You done.
you that press also for the petition. Please for adjournment on the ground that he needs to communicate with his client as to whether the petitioner wants to pursue the case.
Yeah.
He's up, Mr. K.R. Patgiri
For respondent number 6.
for the response number 6. Submit that. As per his information, the petitioner has joined another college and as such the writ petitioner is becoming public. And this is the matter on 29.
29.
Public. 25.
Here the petitioner has been left out as drop teacher, although no. So he is paying for
Dropped when?
drop teacher in drop teacher from since the school was provincialized on lordship 1991. 1991. Okay.
Here we are dropped since 1991.
Yeah, provincialized in 1991.
And several high power committees has been formed.
So you are dropped in 1991. What remains?
They are yet to consider my
You joined the school when?
let's say 1988.
You joined the school in 1998,
1988
88. As what?
as assistant teacher.
It was a venture school.
Franchise.
So what is your right to be provincialized?
Notification dated.
Huh?
Under notification dated notification dated 13 January 2003, 2003, Annex 3, page 19.
Page?
Page 19, notice.
Page 19, yes.
Clause 1, the teacher must have put in at least 2 years of continuous service immediately preceding the taking over of the concerned schools by the government. The appointment of the drop teachers must.
This is of 2003, Mr. Council. You were dropped in 91.
Yeah.
Finish.
Okay, there are several high power committees have been formed.
What is your right to be provincialized? That's what I'm asking you.
Okay, since I am kicked out as drop teacher, okay, in 2000.
How many teachers could be provincialized that time?
Provincialized was made on that way, but those who are left, those who were serving, continuously, they were taken as assistant teachers. Now that has been converted to tutor. That's a new act.
What is your case? I don't. Yes, Sadhu.
The page 10 is the fair minor.
Huh?
Page 10 is the fair minor. He's praying for provincialization service under the Act of 1977. Now, my lord, provincialization can only be done in respect of
2017.
7.
Now it has been turned to tutor.
Whatever it is, can this prayer be allowed? Is the 77 Act, 77 rule, still in force? Is it still in force?
In the
I don't know. You tell me. I've got no idea. Is the 77 rule still in force?
that is not in force.
Provincialization, let us see. Yes, Mr. Any idea? Is it in force? Can provincialization be done as per the? I know. Let me see the 77 rules. As 17 Act. Yes, madam.
Now we the provincial can only be done in respect of 2017.
So it may be considered lordship because I have a representation at Annexa 8 lordship, page 38.
How can it be done under that? This 91, you were dropped. This is 2025. Show me under why you should be considered under the 1999 Act.
Lordship, since he is serving continuously and lordship, and I
Let us see the 1990 Act, 99 Act or whatever it is, but under the 1977 Act. Let us see the 1977 Act. As the elementary province 977, 29. 29. Is the 77 Act still applicable?
that is not applicable.
Huh?
Now new act has come up.
If it's the new act has come, then where is your case? Then you will have to amend your writ petition, or you have to withdraw liberty to file a fresh or something like that.
My representation may be considered by the high power committee though, because the high power committee has been considered I whatever Professor Hazarika Lordship, case Lordship, there is a judgment Lordship. Passed by this honorable court Lordship, page 34 Lord.
Yes, madam, is the 77 Act still applicable?
Well, in the act matter, there is no provision for provincialization of services itself.
There's no provision for?
Provincialization of service line. It has been adopted in the 2017 act. Let him approach the authority matter. That's not a request. 2011.
Look, this 77 rule, Mr. Counsel, is only with respect to recruitment of teachers of elementary school which have been provincialized under the Assam Elementary Education Provincialization Act 1974. Your school was provincialized in 19 under this act or not?
Under this act.
Where do you say that? There is nothing. When was your school established?
Based on whatever.
A school was established, but was it provincialized?
It was established on 88 because these were founder teachers.
Huh?
Founder teachers.
Okay, but when was it? When was it provincialized?
Provincial.
Was it? Huh?
1991.
Under which act?
What's it there? This point of time, I may be given a liberty to withdraw this and file a case on it. So some provisions I have to also give here. So now my rights under this act and new act I have done a few those.
Not only that,
He facilitated that.
you have to show that the school of yours had been provincialized under the 1974 Act. For you to be provincialized under the 77 rule, your school has to be provincialized under the 74 Act. Okay, right. Right, Mr.
S.J. Sharma.
Ajay Sharma, learned counsel for the petition, who feels that he may be allowed to withdraw the writ petition with liberty to file the fit. Ms. Stuti appears for
Elementary.
Elementary Education Department. The prayer of the petitions counsel is allowed. This petition dismissed as withdrawn with liberty of fit. Right.
Let's see the version. Let's see the order dated 16/12/2020 in the office notice. In this order, my lord, actually, the head coordinator has to make inquiry into the matter and file affidavit. If that they have not filed affidavit. Kindly see the last portion. The customer number 3 being the state coordinator of AFL.
This is with regard to certain materials you had bought in 2017. Yes.
I have received my instruction, my lord. I'll have my affidavit, but it is the deputy commissioner who should have taken the instruction. They have taken the amount, but not supplied the. Yes, no, sir.
Deputy Commissioner. Who is for the Deputy Commissioner? Yes.
So, Lordship takes the page number 50, my lord. Additional deputy commissioner already given to the all the member secretary. The list.
Page 50.
So, Lordship will take the same load of 46. 46 to 50 are same. This is a letter from the additional deputy commissioner education, my lord, that if the to the school, my lord, concerned school, that the legal action has to be taken, my lord, if this action has not been taken. Because the supply order is there, material money has been taken, but material not.
Material not supplied by this supplier.
Yes, supplier. That's why they have made private parties, my lord.
Supplier also.
This is a civil case or what? Where is how is the DC involved? You ask for supply of certain material.
Yes, sir. They asked to deposit the money in favor of the JSP enterprise. Additional deputy commissioner and B. Annex of 6, madam. Page 27, annex of 6.
Next is 6.
Annex of 6.
Page
Page 27. In this regard, I instructed to you that the process of the engineering building structure PB may be used as a approach the engineering building materials manufactured by firm like.
So are these firms the parties here? Are these firms parties here?
They have made private parties.
That's what number 10 and 11.
Okay, right.
But they are the private customer land, but actually action has to be taken by the government of it's your additional.
Right.
They ask to
The petitioner's case is that they were made to purchase certain engineering building structures, building materials from the respondent number 10 in the list. Though payment had been made, the required building materials had not been supplied to the petitioner. Mr. S. Bora appearing for the respondent number eight.
I'm referring to 3 and 6.
Huh?
3 and 6.
3 and 6. Who is for the SSA?
That's SSM, these are SSM.
What about 8?
8 is deputy.
He's also come district
He's the
mission
deputy
coordinator.
commissioner, but he is deputy commissioner, district mission committee. He gets an additional charge.
What about 9? District project engineer SSA.
They are done the district project SSM.
Huh?
I will have to take
You have
Nine.
9 also.
9.
So yours respondent number 3,
6 and 9. 6 and 9.
3, 6, and 9. Submits that he has received para-wise comment and he will be submitting affidavit within
Not within 3 weeks.
3 weeks. Mr. P. Saike appears for 7 and 8. And he is also granted 3 weeks time to file affidavit. Miss appears for respondent number 10 on behalf of Mr. M. Sharma. Respondent number 10 shall also file affidavit within 3 weeks.
Allegation is against them.
Huh?
Allegation is
Correct.
against them.
They have got to file. And what about 11? Mr. G. Pegu appears for, huh? One, two, four, five.
Has not been, service
Huh?
has not
I will respond, this 11, respond number 11. Service is not complete.
been, sir.
You have to take,
But he is under 10, my lord.
Huh?
Under 10, my lord.
Huh?
Number 11, under 10, my lord.
Under 10.
It's under response number 10. Response number 10, he authorized the JSP enterprise. He's the undertake, undertake enterprise.
you should take a fresh step, my lord, also,
Huh?
respond number 11.
Response number 10 is the company, my lord. Main company.
Then it's the company product.
Maybe, but 11 also you have made a party. Why did you make a party? Don't make a party. If you make a party, then you have got to take steps against the party also. Huh? 11. Who's that?
That's why we will take the steps.
No, wait. Item. The cause list shows that the respondent number 11 is represented by Mr. J.I. Borbuya and Miss F. Bigam. Miss F. Bigam, comma, Mr. L. Mohan and Miss K. H. Chowdhury and Mr. S. Paul. The respondent number 11 is accordingly also directed to submit affidavit within 3 weeks. This is the matter after 3 weeks.
The petitioner manual initially appointed.
No, don't give me the story. Yes, affidavit. Huh?
If, affidavit is something filed, but if.
When will you file?
If
The matter of
sometime-
51.
sometime-
21 matter, Madam, 4 years have gone.
Sometime you'll be granted to.
How much more years do you want?
Sometime you'll be granted to file a red.
How much time? It is noticed that despite a lapse of more than 4 years, no affidavit has been filed by the BTC and by the KAC. KAC. Miss S. Kempline, Learned Counsel for the KAC, is accordingly granted 3 weeks time to file affidavit in a position. This is a matter of
Lord, I have filed an affidavit today itself. So, the matter may come up along with that executive.
What about you are appearing for? So you are, okay, Mr. PJ Phukat, counsel for the
Got inverted. Respondent one and
respondent number 1 and 2. Appeals that he has filed affidavit today.
Lordship, my name is BB Gawat. The date may be fixed, Lordship.
Yeah, are you filing any reply affidavit?
We have already filed, Lord. Because opposition, we have
No, how can you have filed it to
we
for
will file it
respondent?
next day.
For him, are you filing?
We'll file.
How much time do you need?
Maybe-
Mr.
BB Gawat.
BP Kakoti, learned counsel for the petitioner, is granted 3 weeks time to file affidavit in reply to the affidavit filed by the respondents number 1 and 2. This is a matter. After 3 weeks, the matter, the present petition is a challenge to the appointment of the respondent number 3 as a state officer. Correct?
Obliged.
I feel so, Lordship. Lordship, matter may be taken up to sometime.
No, there's nothing. This thing is here.
Lordship, my senior is lack on court number 80.
Let him remain there.
My lord, yes, my lord, your lordship, that order, your lordship.
Yes. So let it be decided by the
Your lordship can send it.
secretary.
Send it.
Okay, right. Heard Mr. P.D. Nair, learned counsel for the petition. Also heard Mr. for the secondary education. Mr. U. Sharma appeals for the secondary education. Then Mr. T.J. Mahanta, learned counsel appeals for the respondent number 6. Then you take this order dated 17/3/2025.
Only observation that my lord, after appearing court side, looking all the records, verify.
Para 2, para 3, para 4. Okay. Next para. Mr. T.J. Mahanta, learned counsel, senior counsel for the respondent number 6, submits that he has got no objection to the prayer of the petitioner's counsel for referring the matter to the secretary to the government of Assam Education Department to take a decision
Considering
after considering the record and
all elected.
giving an opportunity of being heard to the party. Next. Mr. U. Sharma, learned counsel for the secondary education department, also submits that he has got no objection to the prayer made by the petitioner's counsel. Next slide. In view of the consent of the parties, the secretary to the government of the education department is directed to take a decision as to the basis for making the seniority list of the incumbents therein. He should also take a decision as to what should be the basis for making the seniority list between the parties, which includes the petitioner and the respondent number 6. Thereafter, the seniority list. Thereafter, the position of the respondent number 6 and the petition, the seniority position of the petitioner and the respondent number 6
Will be reflected in negative.
should be reflected in the gradation to be so made. The entire process should be conducted by the secretary to the government of Assam, secondary education department. After consulting the record and giving an opportunity of hearing to the petitioner and the respondent. The entire process should be completed within a period of 2 months. 2 months from the date, 3 months from the date of receipt of a copy of this order. The writ petition is accordingly disposed.
Your lordship, in this case, twice the petitioner has been directed to be considered for transfer. He submitted the application to the this honorable court directed by passing two orders. And in the meanwhile, they have also passed a speaking order, your worship. If your worship comes to page 40 and 41, 40 is the last order, your worship. Page 40.
What is your case? You want to be transferred?
That your worship, that your
Now they are saying that you cannot be under section 7.
lordship, that is
Let us see section 7.
that your worship 10 years is required to be inter-district. Your worship. That's what I wanted to point out, your worship.
Then if you are not eligible as per rules, then
Now
what
your
remains?
worship, as per the new, when this new scheme of is put in place, your worship, the act, your worship.
No,
I have no-
you see, scheme cannot override the act.
No, not the scheme, the scheme of the act. That the act provides for 10 years service in a particular district.
Then-
Your worship. I'm not
You're not
eligible under
fixing.
that.
You withdraw. What do you mean?
Lordship.
What do you mean? If
Your lordship,
prayer is
suppose
for
if
transfer.
your lordship, since I don't have any instruction on that.
okay, I will
your
decide the
lordship-
matter. Then I'll decide the matter.
Your lordship will decide the matter.
Decide the matter.
That's
no
the
problem.
agenda.
Okay, right. So let me see there of the Assam Elementary Secretary
That
Regulation
is
of
your
Social
lordship will get it at page
Page.
page 8.
Huh?
Page 8, your lordship. Of this book. The
Okay,
Assam-
page 8.
relevant section
Seven.
7, page 14.
7, 8.
Lords. 7A, your lord. There it is.
So that's it. And you have worked for how long?
I have worked for your lordship since 2017.
Nearly. Wait for another 2 years. Okay, right. Heard Mr. S. Varthakur, Learned Counsel for the petitioner. Also heard Mr. U. Sharma for the Secondary Education Department. The petitioner, no. Right. The petitioner's prayer in this petition is that his application for transfer to his home district, has not been acceded to by the authority. Even though the petitioner has been working as a assistant teacher, as a subject teacher,
Postgraduate teacher.
as a postgraduate teacher since the year 2017. Mr. U. Sharma, counsel for the Secondary Education Department, on the other hand, submits that the petitioner cannot be transferred to his home district in terms of section 7 bracket A of the Assam Elementary and Secondary School Teachers bracket Regulation of Posting and Transfer bracket Post Act 2008. Hereinafter referred to as the Act 2020, sorry. Hereinafter referred to as the 2020 Act. In as much as the teacher can apply for transfer to his home district only or to a nearest contiguous district only after having worked continuously for 10 years. In the present case, the petitioner has put in only 8 years of service. Next one. A perusal of Section 7 bracket small a of the 2020 Act clearly shows that a teacher working at in a district continuously for 10 years or more can apply for transfer to his or her home district or to a nearest contiguous district. In view of the petitioner having worked for only 8 years, the petitioner does not have any rights to be transferred to his home district or any other contiguous district. In view of the reasons stated above, there is no ground issue any direction to the respondent authority for transfer of the petition outside the district he is working. The petition is accordingly dismissed.
Obliged.
Yeah. No. Yes,
Hello, I'm filing affidavit today.
reply today.
Filing.
I'm on behalf of S. Chakraborty, representing respondent number 6 and 7.
Have you filed affidavit, madam,
They have
You
filed,
filed.
I am filing reply.
to their affidavit? Okay, okay. Mr. Yeah, M.R. Kandakar, Senate Counsel for the petitioner submits that he is filing affidavit in reply today.
Today.
To the affidavit filed by the respondent number,
Respondent number 2,
Six as-
direct.
respondent number 2. Miss
D. Hazarika,
D. Hazarika appears on behalf of
H. Chakraborty,
H.
respondent
Chakraborty.
number 6 and 7.
S. Chakrabarti for respondent number 6. List the matter after vacation.
Complex. Matter related to the completion of appointment lawsuit. In this case, lawsuit similar matter lawsuit already differed with honorable court lawsuit similar order.
I don't believe you. I don't believe the similar order is required. Are you sure? What is your case? Who died? Your mother died. The petitioner's mother died.
Other directors.
Father died while working as
Assistant teacher
where?
in public areas in school Hyderabad.
When did he die?
Right, 4/4/2014.
Then what happened?
Age 59.
Huh?
Standing field of 59.
59. What happened to 59? 59. Yes. What about 59?
My senior late
No, no.
after
You were arguing. No, no. You tell me.
my senior late after
Who filed the application for compassion appointment? Anybody filed? The mother filed, the son filed, who filed? Son filed. When did he file? Before the death or after the death? No, no, when did he die? You look, when did he file? Let me help. It's better. Come to para 5. Please read. Read.
appointment grade and 4/4 that applied on
When? Applied when?
23/6/14. 2014.
14. Okay. Now, can you apply for a grade 2 post? It says here grade 2. In the second line of para 5, it says grade 2. Can someone apply for a grade 2 post? Why didn't you apply for a grade 5 post? Okay, has Miss
Yeah.
J.
After.
Akhtar appearing on behalf of? Is your name here in the thing, in the thing? J. Akhtar is there. That's okay. Miss J. Akhtar appears for the petition. While Mr. P. Saki appears for?
That's for them, 1, 2, 3, and 5.
1, 2, 3, and 5. Mr. U. Sharma appears for?
I am for the respondent number 4 and
4 and 6. That's all. Anybody else?
One.
4 and 6. Huh? Okay, disposed of.
But I have received the status report. The
Copy to him.
statement of many witnesses have been taken up and a lot of,
So what is the finding?
no, it is not complete. It is not
So some more time will be.
some more time.
Right.
We-
Mr. Dina has submitted the status report dated 3/4/2025. Submitted. No, it's issued by the Superintendent of Police, Chief Minister, Special Vigilance, SM, in pursuant to the order dated 5/2/2025. He submits, first off, he submits that the investigation is still ongoing and they need further time to follow up on the investigation that is being carried. Accordingly, this matter, when
Let it be after 4 weeks, implement the vacation is there.
this is the matter, on, this is the matter on, 14 May.
What is,
So at long last, they have at least started investigation.
Lordship, may the status report very kept up.
Okay, the status report dated since is made a part of the report. Anyway. And marked as an X. Today's date is 8, no? 8.
How about that?
I'm being item 16. Oh, it's still there.
This item may take on 2, Lordship.
No, it's okay. I'm ready. Tell me.
One of it.
We can take till 2 o'clock also. No problem. I'm ready. Oh, his senior is on late. Okay, 2 o'clock.
Obliged.
We keep it here only. So,
My sincere apologies for not being available at the first call. In this writ petition, my lords,
Basically challenging a notification, my lords, of 2nd January 2024, by which the state did not consider me the petitioner for the post of primary teachers, relying upon an honorable Supreme Court's judgment. I am a diploma in elementary education course, for short DLED candidate, and I have completed my course in 18 months from under a Government of India scheme from National Institute of Open School. The requirement of state to apply for this job is that you should have a 24-month diploma. But under a Government of India scheme, I did
So
my.
the state requires a 24-month diploma.
I'm sorry, my lord.
The state requires a 24-month diploma.
Under the NCTE guideline. As per the NCTE, because National Council for Teachers Education prescribes the guideline, and NCTE says 24 months is the period for which one should have done diploma in elementary education to apply for a post of a primary teacher.
And you have done it under
18 months approved by NCTE from NIOS, National Institute of Open School. Once this course was introduced, my lord, the NCTE said that both these courses are equivalent. So therefore, in 2019, in 2020, in 2021, all three recruitments that happened prior to the Supreme Court judgment, the state called similar applicants like me and included us in the recruitment process. Thereafter, for one state of Uttarakhand, one judgment came from the Honorable Supreme Court in November 23, 28th November 23, by which multiple states felt that my diploma, my recognition has been nullified by the Honorable Supreme. So thereafter, within 10 days of that Supreme Court's judgment, the state issued a notification saying that people like me are no more eligible. Multiple review petitions were filed before the Honorable Court.
For which course?
For post of a primary teacher in state-run schools. Primary teacher in state-run schools. The post will be assistant teacher. The name of the post will be assistant teacher. Assistant teacher in primary school. That is the job. So, my lord, after that, what happened? That one state did not include me. Some petitioners likely came before this honorable court in a batch of writ petitions saying that we are not covered with Javeer Singh. Therefore, please consider it. That is a different batch. Some of us, my lords, including from the state of Assam, went to the Honorable Supreme Court that, see, everyone is misunderstanding your order. Therefore, please clarify that our course is a valid course and we are eligible. After hearing all of us, my lords, including some of us from the state of Assam and the state which was a party before the Honorable Supreme Court, on 10th December 24, the Honorable Supreme Court clarifies that yes, your course is valid and it is at par with the 24 months. The Honorable Supreme Court clarified. State of Assam. It not just clarifies that. I'll show the documents. I just wanted to give the brief. It not just clarifies, it also says that the clarification will be applicable from a backdate. Now, which is the backdate? The backdate is the judgment which they had passed, relying upon which the state came out with this notification. So 10th December 24, the Honorable Supreme Court clarifies with a backdate, with state of Assam being a part.
In which case has it clarified?
In Javeer Singh versus Union of India, my lord, the order, my lord, would find at page 46. The same judgment where they relied upon removing.
And where is the earlier judgment?
The earlier judgment is also Javeer Singh. The earlier judgment is not on record, my lord, by which they removed me, that is not on record. But by which it is clarified is on record because it is filed in the very same SLP. Because that it was
a different case.
Same case. Same case. The judgment which was passed by the Honorable Supreme Court saying that the court.
What was the judgment passed in the earlier judgment? Let me see.
Javeer Singh versus Union of India.
Which date?
Javeer Singh was state of Uttarakhand, 28th November 23. 28th November 23.
23.
Yes. In that judgment, against that judgment, review petitions are filed. And that
judgment is not here.
That judgment is not here.
Why?
Well, we just wanted to place the
how it is.
November 23. In Civil Appeal 7873 of 23, it is a reportable judgment.
Civil Appeal
7873 of 2023. Judgment dated 28th November 2023. And then my lord would kindly come to page 46 of the writ petition for a minute. Page 46. Page 46. My lord would see on top, review petition civil number so-and-so on the top, my lord would see. In Civil Appeal number 7873 of 23. My lord, that page 46.
What is the review number?
The review petition number is 4961. 4961 is the review number.
The review.
Four 4961 of 2024.
This is their number. There is a review
It-
petition
it-
number.
No, this is the only, because I had the opportunity of filing this review, Malad, I had only filed it. At this stage, Malad, because there was a delay, the review petition number never came. It was only at the ID stage. Unless the delay is condoned, therefore it will not come. And in the same page, if my lord would see in the same very page, fifth application, which is miscellaneous application die number 42144. Fifth application is where state of Assam is a part. The same page, page 46, fifth application number, MA die number 42144 of 24. That is where state of Assam is a party. And now the relevant part comes at page 47, my lord.
How thick is it? 47.
Yes, 47, para 3. May I read, my lord?
Yeah.
However, to avoid any confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on 10th August 2017 and who have completed the diploma course of 18 months would be treated as a valid diploma holders for the purpose of applying in other institutions or for promotional revenue.
Who are in employment.
In employment, very, very important. All of us are in employment.
As on 10/8/17.
2017. That is the first condition.
So are you in employment?
Yes,
for 10/8/17?
I am in employment. I have produced my proof in this writ petition. For each petitioner, I have produced.
No. So why have you come if you are in employment?
Yes, the answer to that is this, Lord, that I was in employment in a private school when on 10th August
You are in a
2017,
private school.
in a private school.
Private school doesn't count.
My lord, the Honorable Supreme Court has examined this, whether I was in employment in a private or a government at a later order, which I will just show.
So you were in a private school.
As on
When did you join a government school?
I have not joined, Maloj. I am applying
Oh,
for the
you're
first
not in a
time.
government.
I have never joined a government school. If I was, therefore, I am applying for the present post, which is of a government school. And this query, which fell from my lord, has been clarified by the Honorable Supreme Court in the subsequent orders, which I'll just show. So I was just reading that para 3, my lord. Valid diploma holder, first condition, in employment as on 10/8/17. Second condition, that should have completed the diploma course of 18 months. That is the second condition. Would be treated as valid diploma holders for the purpose of applying in other institution or for promotional revenue. And then para 4, my lord. Needless to state that the clarification will be effective from the date of pronouncement of the judgment under review. The judgment under review is, my lord, 28/11/23. The advertisement, which is a subject matter of the present writ petition, is 26th December 23, 1 month later. So this is a clarification the Honorable Supreme Court gave.
Yes, sir.
Hello.
What is this recognition order?
Because the recognition order is basically the course that I have done, which is the 18-month course, that was approved by the government and NCT. Because all of us who were in service, we didn't want to lose our job. Therefore, government made an amendment in the RTE Act saying that whoever is in service can be trained while being in service. And this course of 18 months, which I am doing, was recognized by the NCT by an order of September 2007. So this is the recognition order which is mentioned.
Please read para 2.
My lord, we have already clarified in the judgment under review that one-time scheme was provided solely to safeguard the interest of those teachers who were employed as on 10/8/17 We are therefore not inclined to entertain the present review petitions as well as miscellaneous applications.
So this is only to safeguard the interest of those teachers
Indeed, my lord.
who are already employed as on 10/8/17.
And all of us are employed, my lords, we have produced.
The issue is whether this this order covers private schools
Yes,
as well.
that is-
Government.
Yes, that has been covered, my lord. If my lord would just have the next, because this is the order, the primary order for clarification. Then the Honorable Supreme Court implements this order. And that is something which will throw clarity on the fact that whether government, private is important or not important. Can I just show that? And that will clarify, my lord. Kindly come to the first order of implementation, which is at 118. The earlier order is passed by a different bench, Justice Gawai. This order is passed by a different bench, applying the order of the Honorable Supreme Court, but for a different state. And I had the opportunity to assist the Honorable Supreme Court in this matter at 118. My lord would have 118.
Yes.
My lord, this is an order passed in the state for the state of Bihar. My lord would kindly come to para 3, which is at 119. And the date of this order is 2012, 10 days after the earlier order. Miss Manisha so-and-so appears for the NCT and so-and-so. Counsel appears for the NIOS. They both are supporting the applicants. Miss Karya also submits that the open so-and-so is recognized by the NCT. Then the relevant part is reproduced in para 4. Para 6 is important, my lord. In the interim, we deem it appropriate to allow the participation of the applicants in the counseling process being conducted by the Bihar Public Service Commission. The outcome of the counseling process, so far as the applicants are concerned, be kept confidential. This is made subject to further orders to be passed in this applicant. So therefore, my lord, in the state of Bihar's matter, this is implemented. And then, my lord,
Not exactly. You're just allowed. I mean, it's not implement.
my lord, this is one order.
It's subject to the outcome.
Yes, this is one order. I'm showing 2 more orders. Kindly have for the state of Uttarakhand, my lord, there's a detailed judgment passed, and that will clarify my lord's doubt on whether in service would mean primary or secondary, because the order of the Honorable Supreme Court says in service as on 10/8. And when the NCT recognition order came, that also said you have to be in service, whether in government, private, that is irrelevant. That is what the recognition order says. But this, my lord, would be clarified at page 400. Kindly have 400 for a minute. This is further clarified, my lord. My lords have page 400. I'm sorry.
Yeah.
Lords would see this is a judgment passed to the state of Uttarakhand, my lord.
Yeah.
My lord would kindly have the para 1, what is being considered by the Honorable Supreme Court. This is 1 month back. By way of this application, the applicants have approached this court for a direction on the respondent to permit the applicants who are holding the 18 months DLED qualification from the NIOS under the open and distance learning mode to participate in the ongoing counseling process and to subsequently be appointed to the vacant post in the ongoing recruitment. This is the issue. Then my lord would kindly come to page 404. They are talking about the original judgment, my lord. Page 404, para 9 is important, my lord, after this. I will just take 2 minutes on this judgment, my lord, because it is slightly important. Page 404, para 9. Challenging the aforesaid judgment, this is the original judgment, and order passed by the High Court, a batch of appeals came to be filed before this court. The said appeals were decided in the case of Javeer Singh and others versus State of Uttarakhand, dated 20th November 23. In the said judgment, if one of us is a member, this court upheld the validity of the rule. In the aforesaid case itself, this court had clarified that the scheme was framed by the Government of India by the aforementioned recognition order was done in order to provide a one-time opportunity to such of the teachers who were already in employment as on 10th August 2017 to get a qualification of a diploma course as required under 23(2) of the Right to Education Act, which had been inserted by the 2017 Amendment Act with retrospective effect from 1st April 15. I will pause here for a second. The RTE Act does not differentiate government school, private school, does not. It simply says that whoever is in employment has to get this qualification. Now kindly have with me further, my lord. Then, my lord, para 12 is important. It appeared, because the same confusion is my grievance in the present writ petition. It appears that there was some confusion in some of the states, and therefore review petitions, miscellaneous applications were filed. Kindly have para 14, my lords, then. This court clarified via para 3 and 4 of order dated 10th December 2024, titled as so and so as under. The two paragraphs which I read, my lords, are reproduced in page 406 and so. Then, my lord, may kindly have para 15. The grievance of the applicant herein is that though they are eligible as per original judgment of this court dated 28th December 2023 and the clarification dated 10th December 2024, in as much as the advertisement in the state of Uttarakhand is dated 29th May 2024, this is after the judgment was delivered on so and so. It is submitted that in reply given by the state government, it is stated that the selection process is almost complete and therefore the claim of the applicants cannot be considered. Just to distinguish on fact note, here the selection process is not even commenced. Only document verification is going on. There is no appointment. In state of Uttarakhand, 90% of the appointments were done. Then, my lord, would kindly come to para 20, which is at 407. In fact, para 19, which is the identical situation vis-a-vis state of Assam as compared to state of Uttarakhand. Kindly have para 19, page 407. This is the learned counsel appearing on behalf of the state. On the contrary, submits that while judgment dated 20th November 2023, this court had upheld the 2012 rules of the state of Uttarakhand, which provided that a diploma for 2 years or equivalent was necessary for being appointed as teacher. She further states that any interference at this stage would cause the complication in the selection process so and so. Now, please see 20, my lord. No doubt that this court has upheld the 2012 rules framed by the state government while judgment dated so and so. However, that is where I fit in, my lord. At the same time, this court had clarified that such of the teachers who were already in employment as on 10th August 17. Again, there is no distinction that they are citing to.
I don't know. That is the issue we have to fix. Carry on.
Would be entitled to the benefit of one-time scheme provided by the Government of India. This court held that such of the teachers who have completed the diploma course of 18 months would be treated as a valid diploma holders for the purpose of applying in other institution or for promotional revenue. Now, 21 is very, very important. Indisputably, the other institutions would also include the schools run by the state government. I would pause there for a minute. Look, if I am already placed in a state government school, where is the need for me to again reapply to any state government school? If, my lord, I am already working in a state government school, what was the need for me to reapply to a process, my lord, to say that now please consider me? Hence, they have said, my lord, that's indisputably other institutions, meaning where you are not working, would also include the schools run by the state government. So, when this argument was tendered, my lord, and the basis of review was that if I am working in a private school and I want to switch to a government school, then why wouldn't this course, in my humble submission, be equivalent? And therefore, the Honorable Court answers the query that we had put, the state had put, that when you have to apply to other institutions would include the schools run by the state government.
So you mean to say everything was decided for private schools? Is it?
What I mean to say, my lord, that
was the entire issue with regard to private schools, and then at the end, the Supreme Court had said that the other schools, it also includes government schools.
What was decided earlier, my lord, was not covering the fact that they were in service or not. In fact, in the original judgment also I can show, they have always protected in service. Now what they are saying is that whoever was not in service, we don't care about them. But whoever was in service on 10th August 17, we are protecting them. And that is what flows from the main judgment also. But somehow, my lords, most of the states did not misunderstood in my respectful submission that judgment. And hence this clarification is coming. And then kindly see further also.
You see, what I don't understand is,
My lord,
do the Do your petitioners have a problem with private school?
Well, the answer to that is this, my lord. On 10th August 2017, my lord, after that COVID came, most of these schools have shut down. So therefore, my lords, I have completed, this was the course had to be completed by 31st March 2019. I have completed the course in 2019. Thereafter, I have lost job, my lord. I don't have a job. The relevance of this 10th August 17 is flowing from the recognition order. The recognition order says that you have to be in service as on 10th August 2017. Now the Honorable Supreme Court says so. So therefore, when we argued this review petition, my lord, and I can say with that responsibility, my lord, that our argument was that if the schools have shut or these government schools give us a better prospect, then why should I not be considered eligible to apply for these government schools? And therefore, in answer to that, all this is being clarified. And this is not the one, this is not just one instance. This is one of the judgments of Uttarakhand. 5 days later, there is a judgment of West Bengal also on the same issue by the Honorable Supreme Court, where they say that wherever you are in service is irrelevant. You have to be in service.
Where is that?
We are just getting a copy of it. It's just 2 days back. Lord, I've asked my colleague to get a copy. 2 days back, they pronounced it. Again, we had the opportunity to assist the Honorable Supreme Court. But kindly have the next, my lord. Just one more paragraph in this, and I'll be done with this, my lord. Para 22. We find that the case of the present applicants would be covered by this court's clarification dated 10th December 24. Now, my lord, these applicants were represented by me. I know for a fact that all of them were private school people. The present petitioner are also in service in private school, my lord. So there is no distinction in facts in both these cases. I have, in fact, if my lord would want to see their documents, I can show their documents of these people who were before the Honorable Supreme Court. All of them were in private school as on 10th August 17, but this was never the issue that where were you in service. And then, my lord, kindly see 23. We therefore direct the state government to consider the claim of the applicants in accordance with the clarification dated 10 December 24. And if the applicants are found to be eligible, to appoint them in accordance with law. The same shall be done within a period of 3 months from today. We further clarify that while doing so, the state government would not reopen the selection already conducted. Here, there is no selection that has been done. And then, my lord would see on the next page, the writ petition. In fact, because this was a transfer, my lord, at 410, my lord would see. The writ petition is, transfer petition is also allowed. And the writ petition, which my lord would see at 411, the prayer, my lord would kindly have at, at page 409. 409 record that the writ petition also stands allowed. Now, this writ petition, which are mentioned for the state of Uttarakhand, are identical to the present writ petition. I say it with responsibility because I filed both. And this is one of the examples where Honorable Supreme Court is implementing, my lord. I have placed on record other High Court judgments also. That how the other high courts have also implemented this is also of relevance because everyone, my lord, except state of Assam, seems to be understanding the position set out very correctly in my humble submission. And my lord would kindly have just 2 such examples, which my lord would kindly see at page 398. 398 is how Calcutta High Court has dealt with the same issue and granted a relief in favor of the petitioner, saying that yes, you are covered. Therefore, you are eligible. Therefore, you are appointed. Has gone to that extent. 2 such examples I have put in. If my lord could kindly have 398 for a minute. $398. And there it is dealt with the primary school only. In fact, that query that fell, my lord, that is categorically dealt with. Of course, it is not binding, my lord, but it's only for reference to assist, my lord. That's how the different high courts have taken a view. Kindly have 398 for a minute. This is the Calcutta High Court, my lord. My lord would kindly see the petitioner on 10th married.
Yes.
The petitioner on 10th February was appointed as a teacher in Loreto St. Mary's Girl Primary School, a Christian minority school, not a government school. Subsequently being selected in the recruitment process, he had joined St. So-and-so pre-primary school. As her such appointment was approved by the so-and-so, the respondent so-and-so. The said approval, however, has been withdrawn by the impugned order dated so-and-so on the ground that training qualification of the petitioner, that is 18 months DLED course conducted by the NIOS, is not a valid training qualification for the appointment of teacher in a primary school as held by so-and-so. Then, my lord, the next paragraph. The Honorable Supreme Court on a review application by order dated so-and-so has clarified the following, which we just read, my lord. And kindly come to the next page. The petitioner, since is in service and had, well, very, very important at 399. The petitioner, since is in service, no bifurcation of whether government or private, had completed the said training course in the year 2017-19, is eligible to get the benefit of the said clarificatory order of the Honorable Supreme Court. The order impugned, therefore, is not sustainable and is accordingly set aside. The present challenge in the writ petition is a similar order. What is being challenged before the Calcutta High Court? All the benefits accrued to the petitioner upon setting aside of the order impugned be released. WPA so-and-so is allowed. So therefore, this is how Calcutta High Court has dealt with the matter. This is the West Bengal. And these are the 4 judgments where Supreme Court has implemented. 3 I have shown, my lord. I am showing the West Bengal one, which is 3 days prior, my lord. It starts, my lord, at page 16. In this page 16, it starts, my lord. These are just the 4 judgments that have been implemented by the Honorable Supreme Court. Page 16, it starts. So I can just give a back. My lord has that compilation that I have tendered. Page 16, it starts the reportable judgment.
Yeah.
If I can just give the background before reading the judgment. In this matter, my lord, what happened that prior to clarification, the Calcutta High Court held against us, saying that we are not eligible. So therefore, the aggrieved party, as in us, people similarly placed like us from the state of West Bengal, went to the Honorable Supreme Court saying that Calcutta High Court, Honorable Calcutta High Court has held that we are not eligible, relying upon your judgment. Now, this judgment, which I'll just read, sets aside the Calcutta High Court judgment, saying that no, they are at par, they are completely eligible to participate in the recruitment process. So therefore, this SLP was allowed, setting aside the judgment of the Honorable Calcutta High Court, which said that we are not eligible. The Honorable Supreme Court said, no, you are absolutely wrong. Both of these groups, 24 years vis-a-vis 18 months, is at par with each other. They use the word at par. And that is what is recorded in this judgment. So therefore, this 3-4 paragraph may be seen a lot in this judgment, which is of 4th April 2025. My lord would kindly have page 21. Para 4.11.
Yeah.
My lord would see that on 24 July 24, Division Bench of the High Court, Calcutta High Court, by placing reliance on the judgment of this court in case so-and-so, dismissed the intra-court appeal. So therefore, what the Honorable Supreme Court is recording that yes, the High Court said that they are not equal, and then the reasoning comes. Kindly have 4.14. It is pertinent to note that on 10th December 24, the bench of this court, of which one of us was a party, passed an order in the case of Vishwanath and others versus state of Uttarakhand, which I just read, my lord, in a batch of matters containing review petitions and miscellaneous applications, essentially seeking a review of the judgment in so-and-so. Again, my lord, on 21st February 2025, another coordinate bench of this court, taking note of the fact that judgment of this court in the case of Jaiveer Singh, so also the subsequent clarification by order of this court in so-and-so was rendered by so-and-so, directed the registry to place. They're just giving the facts, my lord. And then my lord would kindly have page para 6, which is 22. This gives the relevance of whether it could be any school, which my lord put a query to me, or it has to be only government school, private school, etc. So therefore, my lord may kindly have para 6. The so-and-so learned senior counsel and parent of the appellant submitted that the central government through MHRD by way of letter dated 31st August 2017 had extended the period for training of such of the in-service untrained teachers in government, government-aided, unaided private school. Very, very important. 3 categories given, and we fall in that category is my submission. Government, government-aided, unaided private schools on 31st to 31st March 2019. It is further submitted that NCT, which is the authority for deciding the qualification laws, relax certain provisions of the NCT regulations, thereby reducing the course duration of the 2-year DLED program to 18 months. So the NCT did it, not me, my lord. It is therefore submitted that any teacher who was in service as on 10th August 17 and who was undertaken the 18 months DLED program through NIOS before 31st March is to be considered a valid diploma holder for the purpose of continuing in service, promotional avenues, or applying to other institution. All three things covered. Then my lord would come to page. There's some facts of West Bengal are mentioned, my lord. That may be kindly ignored. My lords may kindly come to page 26, para 13. Page 26, para 13. May I read, my lord? It however so happens that on 3rd August 2017, the central government through MHRD apprises all the states and UTs that in terms of section 23 of the RT Act, the in-service untrained elementary teachers in the government aided, unaided private school are required to be trained. In order to give a statutory effect to the aforesaid letter, the Parliament carried out an amendment in the RT Act, therefore added a second proviso to subsection 2 of 23 of the Right to Education Act, and the same was notified on 10th August 2017. Therefore, this date is important, my lords. 10th August 2017 is the date of amendment. And hence, every court is relying upon this 10th August 2017. Then, my lord would kindly come to para 14. It is pertinent to note that the second proviso to subsection 2 of 23 of the RT Act provides that every teacher, very, very important, or in position, appointed or in position as on 31st March 2015, who does not possess minimum qualification, shall acquire such minimum qualification within a period of 4 years from the date of commencement of the Act. Accordingly, the date of commencement of the Act so-and-so was fixed to be 1st April 2015. The in-service untrained elementary teachers had to require the minimum qualification by so-and-so. Thereafter, my lords, para 15, that how is this was reduced, my lords. It is done by NCT, not by statutory authority, my lords. Para 15 is important. This is the recognition order, which my lord was asking me about, my lord. So therefore, this is important, my lord. The NCT thereafter on 22nd September 2017 passed a recognition order. It is relevant to note that the NCT only after considering the recommendation of an expert committee sought to grant relaxation to certain provisions of the 2014 NCT regulations so as to ensure compliance with section 23 of the RTE Act as it stood amended on 10th August 17. The NCT therefore reduced the duration of the DLED through ODL system, which is me, my lord, recognized in so-and-so. The duration of the DLED program was reduced to 18 months instead of 2 years by including subsuming the 6-month internship within the 18 months. This is very, very important because this was argued that why are they equivalent? It was not reduced, but only the internship was given short. The NCT also granted recognition approval to NIOS for conducting the 18-month DLED program. And then my lord would kindly come to page the recognition order is also reproduced, my lord, which my lord would kindly have page 32. That also deals with 3 classes, my lord, private school, government school, etc. So 32, my lord, the recognition order starts. If my lord would have 32 for a minute. 32, my lord, the recognition order is reproduced. And then the relevant, my lord, is at 34 in bold. 34, para 43 in bold. It further clarifies that the NCT recognition order dated 22nd September 17 was only for those untrained in-service teachers in government aided or unaided private schools who were appointed on or before 10th August 17. The bold part in page 34. And then, my lord, would kindly come to page 35. Page 35, para 26. I'm sorry, my lord, I'm taking time. It is slightly important, therefore I'm putting.
Yes.
para 26, my lord, it can thus be seen that this court observed that since the time gap between the directions issued by the central government was only about 18 months, the period of the course was reduced from 2 years to 18 months. It can be further seen that this court recorded that around 12,91,880 in-service elementary teachers had registered and made payment on the NIS portal as on 30th September 2017. 40 of us are one among those. Not only that, but this court also observed that NCT recognition order dated so-and-so was only for untrained in-service teachers in government aided, unaided private schools who were appointed on or before so-and-so. I fit in that class. And then 2 more paragraphs and I'm done with this judgment. Kindly have page 36, para 28. Page 36, para 28.
Yeah.
It is clear that only such of the teachers who were in service as on 10th August 17, but who had not acquired the minimum qualification till then could have availed of one-time scheme as sanctioned by so-and-so. Having availed of the one-time scheme, which I have done, my lord, such of the teachers, even though they only undertook the 18 months DLED program through NIOS, they should be considered at par with a 2-year DLED if they completed their 18 months program through NIOS prior to 1st April 2019. Any other candidate who was not in service as on 10th August 17 cannot be considered to be at par with the 2-year DLED. Therefore, the only test, my lord, in my humble submission is whether I was in service in those 3 categories: government aided, or unaided private. And then, my lord, would see that finally they hold in our favor, my lord. My lord would kindly come to page 39. Page 39, my lord. The second line from top. Page 39. Page 39, second line from top, my lord.
Yes.
As such, this is an observation or a finding, my lord. As such, any teacher who was in service as on 10th August 17 and who acquired the qualification of DLED by way of 18 months program through NIOS prior to 1st April 19 is a valid diploma holder, and my lord may mark that, and at par with any other teacher who has completed the 2-year DLED program. This is the finding that they give, my lord, the Honorable Supreme Court, that 18 months at par with 24 months. And then, my lords, on the next paragraph, they set aside the judgment of the Honorable High Court. And finally, my lord, if my lord would see the operative part at 42. Operative part at 42, my lord. They rely upon the Uttarakhand judgment, which I just read. And 5 is important, Roman 5. We clarify that such of the teachers who were in employment as on 10th August 17 and who completed the so-and-so shall be considered as valid diploma holders for the purpose of applying in other institutions and or for promotional avenue. And then they further give a direction, my lord, at 43. At 43. We direct that the respondent authorities to consider the candidature of such of the appellants who were in service so-and-so on verification are found to satisfy the eligibility criteria shall be appointed within a period of 3 months from. And the date, it is dated 4th April 2025. So in this light, my lord, what is the challenge before my lord is a 2nd January 2024 notification, my lord, which I am seeking, ultimately setting aside of, and for present, my lord, I am seeking a stay on the same, my lord.
Page.
117, my lord. Annexure number 3. My lord would see, this is a notice of 2nd January 2024, last year, my lord. May I read, my lord? It is for the information of all the concern that the Directorate of Elementary Education, Assam, has published advertisement so-and-so for teachers dated 26/12/23. The date is important, my lords. 26/12/23 is the advertisement. Supreme Court Judgment 28/11/23. The advertisements were prepared and published in compliance with the order passed by Honorable Supreme Court of India in Civil Appeal so-and-so. wherein it is stated that the qualification of 18 months diploma in elementary education acquired from the National Institute of so-and-so is no longer a valid qualification to be eligible for fresh recruitments to the post of teachers. This has approval of the government of so-and-so in Department of School Education so-and-so. So this is one of the challenge in the present writ petition, that ultimately this needs to go, my lords, in light of the subsequent clarification. This, my lord, has to be read with the orders passed by NCT. So based on the Supreme Court judgment, the NCT, because NCT prescribes the minimal eligibility, all states have to follow it. They are the rightful authority under the RT Act. The NCT, after the Supreme Court judgment, has written to the state of Assam in January 25 that please implement and consider them equivalent. And that is also on record, my lord. My lord would kindly have page 413. 413, my lord. I'm sorry, I'm making my lords go through pages there and there, my lord. I apologize for that. My lord, this is slightly, it may not clear. Like, I'm sorry, it is not that clear, my lord. Page 413, if my lord would have. On the right side, the date is mentioned 27th January 25, topmost, and it is by National Council for Teachers Education. The subject is very, very important, my lords. I will just read it, my lord. To forward the order dated so and so.
Yes, anyway, so what is to be done now? What is to be done now?
What is to be done? Look, if I can just.
You're only challenging the notice.
Yes, that is one part, my lord. And there is already a process going on. I have produced that the verification document list on record. For the same very advertisement, my lord, they are verifying the documents of the 24-month one.
The last date of submission of applications expired.
Expired, and I had applied.
You applied.
All of us have applied. All of us have applied. And if we have applied, my lord, there are two things, Lord, what I'm praying for. One, because it is at the stage of document verification, the notice is annexed. And it started like 2 days prior. In fact, last 31st March, it started. There are two things, my lord. One is that all of us, my lord, which is the petitioners, 40 of us, may be called for document verification. That is point number one that I'm pressing, my lord, for. Second, my lord, this notification, in my respectful submission, should have been withdrawn by now because there is an Honorable Supreme Court's order and State of Assam was a party. And then this NCT order, my lord, which is also issued to them, saying that please implement it, which is NCT is the rightful authority.
That is page
413.
413.
It is issued to them, my lord. The Chief Secretary has been served with a copy by the NCT. And the NCT supporting our stand is recorded in the Honorable Supreme Court. So therefore, my lord, my argument or my submission for my lord, kind consideration is twofold. This notification, in terms of the Honorable Supreme Court clarification implementation, is to be stayed, ultimately set aside. Secondly, my lord, 40 of us may be called for document verification, my lord, and be considered eligible in terms of the judgment passed by the Honorable Supreme Court and implemented by other state at par with others. And it is not as if I was never considered. I was considered in 2019 by the state of Assam. I was considered in 2021 by the state of Assam. Lying upon an Honorable Supreme Court judgment, they felt.
So basically what you're trying to say is that the judgment passed earlier has basically been reviewed.
Indeed. In effect, it has been reviewed. In effect, it has been reviewed, my lord, and that is why they have implemented. In fact, whichever High Court followed the earlier judgment, they have now set it aside. Which I just said, one of the state of West Bengal, they simply followed the earlier judgment. And now the Honorable Supreme Court sets aside that judgment, saying that this is not what we meant.
So you took part in the advertisement A and B.
I took participate in A and B.
In
26 December, the advertisement A and B, one is for class 1 to 5, the other is for class 6 to 8. And all 40 of us, my lords, have taken part. We have applied, my lord, because the verification process is ongoing. Therefore, my lord, we would want to participate in the verification process and also stay, my lord. This is very, very important because till this time my hurdle is stayed. They will come back and say that we don't consider you eligible. The question that I put to myself is, my lord, that once state of Assam has been a party throughout, what basis would they have, my lord? Specifically, my lord, even if they are not a party, judgment in rem, my lord, it's not a judgment in persona in my number. So therefore, my lord, what remains specifically when there is a clear-cut direct? And one last thing, my lord, in the other matter, which is the batch that is pending, my lord, there was a stay on the verification passed by a coordinate bench of this court. They went in appeal, my lord, and that all those writ petitions were filed prior to the review. The state went in appeal, my lord, I must be fair to report. The state gave a concession there that we will consider the respondents, as in the petitioner, for verification, but did not make any statement regarding the eligibility. Today, that matter was again listed before a coordinate bench for those petitions which were filed prior to the clarification, where the state took a stand that those writ petitions are prior to the review, therefore nothing can be done there, and the eligibility is still in question. But the present writ petition, and therefore I think it has been listed separately, my lord, is not distinguishing ourselves from Jaivu. We say that we are getting benefit of that order, please implement it for us. That is the short point. So therefore, technically, we may be different from what is happening there. We are only
Anyway, let us hear the other side. Yes, yes.
grateful, my lords, deeply grateful.
Basically, I think they should be also be, they
There
should
is
also,
one confusion left.
yes.
The Honorable Division Bench judgment regarding the physical verification of documents,
Ah,
election where they want to participate.
yes, yes.
First of all, it is not there in the writ petition which is the exact advertisement or selection process they want to participate. Neither there is a statement that this is the particular advertisement, neither there is is it next to the writ petition anywhere. So we do not know which advertisement is talking about.
They have participated in it.
We do not know whether, and there's not one sentence in the entire writ petition saying that, yes, we have given our forms, we have participated, and we are being left. The prayer clause, if Lordship would see, thank you, Lordship would see. That is at page 42.
Yes.
Lordship, page 43, prayer number 4.
Yes.
Direct the respondents to include the petitioners in the ongoing verification process released by notification dated 18/3/25. Direct the respondents to include the petitioners in any recruitment process for assistant teachers so-and-so conducted in the state from 28/11/2023 in adherence to effective directions. Now, in the
So this white notification,
petition, I do not find that they participated. What had happened is, when we gave the notification, we are not allowing the 18 months DLA to participate, people rush to the point. The learned single just rejected the prayer for interim protection, saying that you would not be allowed to participate. The Supreme Court in JV Singh said so. Only in the interim part was rejected. Notices were issued. Those petitioners went to the division bench. Division bench said, allow them to participate for the time being. Do not declare the results. It remained done. Writ petitions continue. We do not know whether these persons have participated or not, because there were two batches. One, before that notification, whoever could apply had applied with 18 months DLA. After the notification, that part was being removed. So they approached the court. Now, again, those people also applied because they were within that particular time frame of the last date of application. And the order for allowing them to apply was also restricted to those.
Here we don't know if
We
they
don't know.
applied.
There is no statement that yes, we have applied. Number one. So this
What we can say
yes,
is that if they have submitted.
Lordship will have the division bench order. Why we made this statement?
Okay.
Division bench order, Lordship. Lordship would have paragraph 9.
Paragraph 9.
Paragraph
Yes,
8.
yes.
Apprehending that they have only 18 months DLA and have been left out of the consideration of the candidature in terms of the said advertisement dated so-and-so, and the names of the candidates for the second phase of physical verification on so-and-so, terms of the said advertisement dated 26/12/23 are yet to be published. The respondents herein approach the court of the learned single judge, preferring interlocutory applications seeking necessary protection. Then, my lord, the interim order is given. Now, Lordship would have paragraph 11. Mr. Saikia, so-and-so submitted that the state does not want to delay the matter pertaining to verification of the documents of the candidates who had applied pursuant to the said advertisement dated so-and-so for the posts of so-and-so. On being inquired, Mr. So-and-so also submitted that during the second phase of such physical documents verification, the authority concerned will also consider the applications submitted by the present respondents. Mr. Saikia submitted that the Directorate of Elementary Education during physical documentation shall verify the credentials. Now, of all those applicants who have submitted their candidatures pursuant to the said advertisement dated 26/12, including candidates having 18 months dated. So this division bench judgment, in fact, will
Covers
cover the case of the petitioners in case they have already applied. It will not cover them if
They don't apply.
if
It
they
does
did
not.
not apply. This is first one. Second one, matters which are taken up by a court bench, the emphasis was made that it should be restricted only to petitioners and applicants before the court.
Naturally, no one wants competition.
Now, if 18 months is eligible, in my humble submission, it's in rem. Everybody will have to be considered. We cannot restrict it to persons. If 18 months is eligible, 18 months is eligible.
No,
If
18 months only for those who have been in service and who have completed
Exactly,
it prior to
all
April
people-
19th.
All people, if it is made applicable for 18 months who had been in service on 10th of August 2017, any person who was there will have to be eligible.
Provided,
Can we
provided
restrict
they, provided they have participated.
it? Can we only
Only those,
and
so it can be
therefore,
limited
in the
only to those.
repetition- In the repetition, not one sentence saying I have participated, submitted my application, I was before this court to do it, I did it under the order.
Lords, the answer to that is this. Lord, my learned friend has not seen the writ petition properly. 3 places, Lord, I have stated that I may be allowed to participate in the ongoing verification process.
No,
But-
that's a different thing.
Yes, my lord, I am coming to that.
Yeah.
All 40 of them, my lords, I have again checked. All 40 of them have applied, my lord. Within 5 minutes, I can give all the application numbers. That's point number 1. Point number 2, my lord, on this aspect of whether petitioner should be permitted or everyone should be permitted, all these 4 judgments of the Honorable Supreme Court that I have relied upon, my lord, I'll show the exact line. They have permitted only the petitioners. They have not permitted anyone else. All these 4 judgments, I can show that line within a minute.
No, you see, that's not the issue.
Yes, my lord, there is one
The issue is this.
my lord,
If you have submitted your application
my lord,
within the last date
my lord.
of the advertisement,
All 40 of us have done it.
then if it is there, then you
All
will
40
consider.
of us have done it.
It
One
will be
second.
considered.
Well, that may not cover for one reason, my lord, because the same very, my lord, the state took an argument in the coordinate bench today, my lord. One second. Sir, if
Did
you
it
don't
file a
mind, I didn't
petition? No,
oppose
you
you.
opposed
I didn't
me.
oppose me.
You have
Please let
opposed
me
me
complete.
every time
Please
I
let
tried
me
to speak
complete.
out.
Please
Sorry.
address the panel. There they took an argument today, my lord, that what we have said before the division bench is this, that we will consider them for verification, but whether they are eligible to participate or not, that we will decide later. Now, the question that I put to myself is, what is coming in my way of eligibility? It is the 2nd January 24 notification. So I have absolutely no problem.
What 2nd January?
My lord, the notification which I just read, my lord, where
Page
they-
117.
I'm sorry, my lord.
117.
Yes, 117, my lord. So therefore, this needs to be stayed, my lord, because again, my lord, this has not been withdrawn till date.
No. That can also that also can be looked into. You see,
My lord, humble submission-
without staying it,
I'm sorry.
otherwise it be amounting to maybe giving you the final relief
My lord,
at an interim
appointment
stage.
would mean final.
No, you see, what we can always do is we can always say that you should be considered, and the final result should not be published without the
My lord,
permission
final
of the
result
court.
for no one should be published, and there is a reason for that. my
That's
lord.
not,
For no one should be published.
correct.
I have absolutely no problem with that. For none of the
So it
Most-
can be done. It can
Yes,
be
what
decided.
What I would suggest is that technically similar petitions are.
No, why should this? I'm sorry, I
On the
oppose
3rd
that.
of May, those matters. are
No, I'm
taken,
sorry.
If I'm not wrong.
He's argued the matter.
Then-
Now he's saying, my lord,
Just
it
a
will
minute,
be
just a
sent
minute,
there.
just a minute. Yes.
Now, we are arguing those matters only on the validity of the 18 months DLF vis-a-vis the 2 years DLF. They are similarly situated is what I understand. What I understand, I may be wrong because false computer. So what I would suggest, this matter gets tackled. Lordship orders that the orders which have been passed in the division bench would cover these matters also. Matter ends.
No, my lords, I'm sorry, that's an unfair statement to make, my lord. After having argued, my lords, when my lords expressed categorically that result for no one should be published because there are 5,500 people, my lord, and I can't be fighting pillar and post if third-party rights are created.
No. One thing.
So then this is coming. I'm sorry. it's slightly
One
unfair.
thing is, you see, it's you are wasting your breath for nothing. The issue is this basically, is that according to you, in terms of the orders, subsequent orders passed, you are entitled to participate. You have the eligibility criteria. we'll allow you to, we'll allow that your verification documents should be done.
Verification.
The document verification should be done. And that at the time of consideration, you should also be considered.
Very
Now that will take some time. It will not finish in 1-2 months. I think it will take at least.
My lord, may just see the notice. 7 days they are finishing the verification. 7 days. This is the notification for a minute. It is at page 71.
Huh?
The second.
The same very notice is at page.
Just a minute, Mr. Counselor. The second verification.
Verification notification will come out because the second verification notification, we have to start after the orders by the division bench. So that notification is yet to. The division bench is verified. Persons who have applied for the statement of their petitioner would be taken into, would be verified.
Why?
This is only
No,
a stage of
no. Why is this all this one division bench, one coordinate bench, one here? Why can't all these issues be taken up by the division bench together?
But there is nothing
that
pending in the
division, that
division.
writ appeal has been disposed of.
Oh, this
Let a big has
All
been
writ appeals
disposed of.
disposed of because they were all against interlocutory orders.
okay.
They are all disposed of. So now if this matter fixed on that, let us not tag it together. Let us fix it on that. Let it be heard on that. 18 months, okay. 18 months, everybody is okay.
No, I'm sorry, Manoj, I oppose that for one
And
reason,
if
my
it is to
lord.
be argued differently, then perhaps
No, no.
we are thinking of presenting different arguments before different
That's
courts. That's what
very
I'm trying-
unfair of my learned friend. In fact, I had the opportunity to assist the coordinate bench also, my lord. Their stand was taken differently, my lord, saying that we are not deciding the eligibility. The division bench's order is only to consider them. Whether they are eligible or not, we'll decide later. Now, once my lord expressed that we will not let the results not be published for anyone, now they say that let it go there.
No,
So therefore, my lord, kindly
that
consider-
was just thinking out aloud. That's nothing.
Yes, my lord, it is about really, my lord. Today, where are we, my lord? There is a direct order of the Honorable Supreme Court clarifying.
Anyway, you see, nothing will happen by which date was that? 5th May.
Third, no, it's not.
When was the
First
next
six-
date? 6th
first
May.
was sorry,
Eighth.
8th May.
It is 8th May, my lord.
8th of May. So we'll fix it on 8th of May. In the meantime, they should allow verification.
For
And
the orders of the division.
huh?
bench. In accordance with the division bench order.
No, there is no,
No,
that
no.
division order.
If they have applied.
Once
yes, if they have applied, that I will clarify.
division bench's
As
order.
per, I will clarify that. If they have applied in any of the advertisements prior to the last date,
Yeah.
and if that is the criteria, if the criteria is 24, since they have 18 and they come within the conditions laid down, that is that by 2017 they should have been in
Yes.
service, and they have
they have
completed
completed
the
diploma. Yes.
thing by 2019, then they should be considered.
Yeah.
And verification should be done.
Yeah,
That
but-
order is already there in the earlier division bench order.
No, I
That
was not
we
a party,
always-
my lords. What is the difference?
then you let
Difficulty in
me- if you
reiterating.
let
I
me
was not a
complete,
party.
you
I don't
understand it.
understand what is the
Okay,
appearance.
okay. I think
It is
I've heard you both.
30 more
I think I've heard you
I
both.
just need 30 more seconds if my lord. to
Huh?
speak.
No. You all have taken 1 hour.
I understand. I'm sorry for that.
No.
Let's just give me 30 seconds.
You're lucky that I completed my board fast.
Look,
And I thought I will do my CAV matters.
I
I
apologize, my lords, that we.
had to leave this thing is 9:15. 9:15 I left the chamber last night.
I sincerely apologize, my lord, for any.
Huh? Yeah, I've got another matter which
We are not the only.
mentioned
culprit.
this morning only.
We are not the only culprit, my lord. But just 10 more.
So you see, the thing is that I've heard you. There's
Well,
nothing
only-
more you
only
can
for
add.
my
right now.
satisfaction, my lord.
Not, I don't want your satisfaction. I want my satisfaction.
I understand. My lord, just
Right.
give me 10 seconds.
Heard, mister?
Well,
What is
Mandeep,
it? Huh?
Mandeep Kalra. My lords, I'm not speaking on the brief, my lords. I'm not speaking on the brief. I'm
Yes.
simply speaking something, my lord,
What?
because I had the opportunity to assist the Honorable Supreme Court in this matter, my lord. My lords, my record that the effective, and not for this case, I'm saying all 40 have applied. My statement may be recorded, no problem. I've verified. But there may be more petitions that may come in, my lords, and I'm saying that responsibility. The Honorable Supreme Court made the review applicable from the date of judgment, which is 28/11/23. The advertisement is of December 23. The
No.
advertisement.
Whatever it is, those who have missed the bus have missed
Yes,
the
my lord.
bus.
I'm just, as I said, I'm not arguing.
No.
on the brief.
Enough.
So therefore,
Enough.
that may also come in.
Enough. Heard, mister?
Mandeep Kalra
Mandeep Kalra. You're
Okay.
from where?
from Delhi.
From Delhi. Oh. Good guessing. uh, learned counsel for the petitioner, who submits that the petitioner had completed their 18-month D full stop EL full stop ED diploma obtained via NIOS bracket ODL mode for recruitment and promotion purposes. He submits that though the Supreme Court in the case of Jaivir Singh, J-A-I, Jaivir Singh and others was state of Uttarakhand and others reported in 2023 STC online SC 1584 had held in para had
The clarification orders.
no, the clarification, the initial order.
The initial order, my lord, would be para 33 on board.
Had held that the 18 months diploma course conducted by NIOS through ODL mode was not equivalent to the 2 years regular diploma. For D full stop EL full stop ED. Full stop. However, while subsequent orders passed by the Supreme Court and especially where is that order, that last order?
The last order of West Bengal, my lord, it is in the compilation.
Oh, yeah.
Start from page 16. The index can be seen, my lord. All citations are mentioned in the index, the first page. The cause title as well as the case date. The index are 16 at start for West.
Yes, yes. However, while order dated 4/4/2025 passed by the Supreme Court in the case of
40 cards.
in the case of Kaushik Das, Kousik Das and others versus State of West Bengal and others. Civil SLP number 19139 of 2024, which had taken into account, which had taken into consideration the earlier judgment of the Supreme Court in Jaivir Singh Stupa and the case and the case of, and the case of Vishwanath, what is that?
Vishwanath versus State of Uttarakhand.
Vishwanath versus State of Uttarakhand. Citation?
Citation will be die number 4961 of 2024.
4961
Yes,
of
2024.
that is civil appeal.
No, it will be die number only.
Huh?
Review petition die number.
Review petition.
Die number. RP diary number.
Where is that page?
That will be in at page, my lord. Page 46, my lord, of the writ petition. Page 46.
Okay. Diary number, huh? What is it? Held that any teacher who was in service as on 10/8/2017 in any government aided / unaided private school and who had acquired the qualification of D full stop EL full stop ED by way of the 18 months program through NIOS prior to 1/4/2019 was a valid diploma holder and at par with any other teacher who had completed the 2 years D full stop EL full stop ED program. Full stop. Yes, sir. The petitioner's counsel submit that as the judgment of the Supreme Court in Kaushik Das Supra has practically reviewed the decision of the Supreme Court, earlier decision of the Supreme Court in Jaivir Singh Supra, the impugned notice dated
Second that.
2/1/24 issued by the Director Elementary Education, Assam, wherein it has held that, wherein it has been stated that the qualification of the 18 months diploma in elementary in DL, D full stop, EL full stop, ED acquired from NIOS was no longer a valid qualification to be eligible for fresh recruitment to the post of teachers should be set aside. Next paragraph. The petitioner's counsel submit that as the petitioners have submitted their application for participating in the selection process for recruitment of teachers in LP and UP schools pursuant to the advertisement -A and advertisement -B mentioned in the notice dated 2/1/2024. The respondents who have started the document verification process should also verify the documents of the petitioners here. That's your case?
And look, this needs to be stayed.
Huh?
This needs to be stayed. Because even if they verify.
No, I'm
that-
not staying. No.
Look.
The stay will come later.
Look,
If you have the case, then the entire, what stay? The entire notice will
I'm
go.
not saying that appoint me for now. I am saying that at least consider me in the merit list.
No,
That is
yeah,
what
yeah,
my
that,
case is.
that too will give you. That too will give you.
Lords, because this is an argument that was taken today by the same very state.
Anyway, we'll see. We'll see. Not
my
on the first day. Some of the
Look,
first.
my kindly, people are bear with me from.
Just-
I'm
just a
not
minute.
asking for a stay
Mr. Counsel, I've heard you. Please.
as my case.
Yeah. You have to rest your case. Otherwise, I'll rest my voice also. All right. Mr. R. Mazumdar, or who? R. Mazumdar. Learned counsel for the
Department of School.
Department of School Education. Yeah, additional? No. That is for B. Gogoi and thing only, no?
Yes, they are.
For the Department of School Education, submit that the issue that has been raised here had also been considered by a division bench of this court in WA 104 of 2025, and that by an order dated 2/4/2025, the division bench had recorded the concession given by the learned Advocate General who had submitted, General, Assam, who had submitted that the Directorate of Elementary Education, Assam, during physical document verification, would verify the credentials of all those applicants who had submitted their candidatures pursuant to the advertisement dated 26/3/2023 of the department, Director
of Elementary Education.
Directorate of Elementary Education, Assam, including those candidates having the 18 months post D full stop EL full stop ED. Huh? He accordingly submits that if the petitioners have submitted their applications within the last date for submission of their applications in pursuant to any advertisement, their documents would also be subject to document verification. That's all. Next paragraph. On considering the submissions made by the counsel for the parties, this court is of the view that if the petitioners have submitted their applications for participating in a selection process for appointment of teachers pursuant to the advertisement A and advertisement B, which are mentioned in the notice dated 2/1/2024 issued by the Director of Elementary Education, the state respondents should allow the petitioners hearing to participate in the document verification. Full stop. Further, in the event the selection process is proceeds beyond the document verification stage, the petitioner cases should also be considered if they pass the document verification.
The earlier VTP judgment says the results are not to be declared.
Yeah, that's right. However, the results of the petitioner should not be published without the leave. Full stop. Next para. As it has been submitted by the parties that an analogous matter, that is WPC number
477 of 2024.
477 of 4 of
477
477
2024
2024 is going to be listed on 8/5 2025. List the matter on 8/5 along with WPC service. Along with
So that is a part heard back. So, my lord,
the same thing, that will cover this. The issue will be the same. If he has heard that, that means he has heard half of this.
obliged.
I'm so deeply grateful for the patient hearing.
What is this?
Lordship, I filed my IA, that is on.
Just a minute. What is this? Just a minute.
Lordship, my IA 1173.
Okay, so you are asking for provincialization.
So, my lord, that is my main case. That is
The
the,
main case. Now, what do you want here?
my lord, in the meantime, now, that is the IA's last page, annexure 4, page 40. That is notification dated 29/3/2025.
Yes,
The notification dated 29/3/05, 2025.
29/3/05.
2025.
Yes,
That is page 40 of my IA.
yes.
My lord, this has said that
Page
Yeah,
14, 14.
40, my lord.
40.
40. This says that all the schools have to register themselves and their credentials in the Durban profile in order for them to be enabled to get registration of the students when the results of HSLC shall be passed. So for me to take HSLC pass student as enrollees, I have to enroll myself first in this Durban port. So my lord, I can come twice before this lords, my lords. One is now, when they allow me to put my credentials, and second at the time when the actual admissions happen. I chose the first occasion, this my lords, because last time when I approached this honorable court during the pendency of my writ petition, I was allowed to take admissions on the last day basis, and I was
No,
successful.
who are you?
51 students, my lord.
No, that was by virtue of the interim order, my lord.
Yes.
A batch of representation has been a hard last
We are
yesterday.
Ah.
Here is court number 20.
Ah.
Batch of repetition, same repetition, my lord. A hard and judgment is reserved. I think 2 or 3 days deliver the judgment. Now this same matter, and now this notification is premature. This lordship understand his apprehension is this repetition batch of repetition is order 2024 and 25 batch enrollment and to get in the name in the portal. Now this notification is for 25 and 26. It is lordship policy. Page 40, last paragraph. It is premature. The Dortmund portal for admission in class 11 for the section 25-26 will be open within 3 days after declaration of results of SSLC examination. Accordingly, classes of first year SSLC examination 2005-26 will be commenced on second week. Already the result is not declared.
I understand, my
So
lord.
what
My
happened?
lord may also consider the second paragraph of the
Wasted of judicial time only.
My lord, to
Nothing
consider
else,
the
my lord.
second paragraph by notification.
Nothing.
As such, all such institutions registered in the Darpan portal are directed to visit so and so to update the institution profile using the existing login credentials from 1/4 to 8 for this today, my lords, in order to process admission of students of HSLC first year for the session 25-26. I understand. But my lord, if I'm not able to get the credentials now itself, I'll not be able to give admissions later on. My lord, they'll cut me to the roots now itself.
This to inform all concerned head of institutions and the online meeting portal Darpan will be live from 1/4/25 to 8/4/24 for
That is today.
registration of new institutions and updating the institution profile. As such, all institutions are directed to visit www.darpan to update.
My lord, if I'm not permitted. if
So
I'm
the,
permitted,
the,
so
the, you see, you,
Maintainable.
Huh?
This notification is not maintainable. His case is in 24-25 session. Now it is a notification for 25-26. He
yes.
is not eligible for admission in the 24 and 25.
My lord,
Only
No.
by virtue of interim order. So by virtue of interim order, they are allowed to get admission. Interim order. And that matter has been finally heard yesterday.
No,
So
I'm not understanding. Look, first of all, this case has got me by surprise. I have not read it because you mentioned it today. So you want to visit the Darpan portal,
I want
correct?
credentials to
Update your institution profile.
Yes,
To using the existing login credentials in order to process admission of student. Now, 1/4/25 to 8/4/25 is the date. 8/4 is ending tomorrow. So that is what the notification says. So are you saying that you will give another date for visiting the profile to visit this Darpan portal?
No, Manoj. First of all, they will have to obtain permission from the government. They don't have this permission.
Permission for what?
We have the
Yes,
we have the
for
account.
admission to open class 11 and 12.
You don't have class
We do
11,
have-
12.
no, that is
Huh?
the- We do
No,
have
no,
permission.
no, they don't
No,
have.
no, so okay, you do not have class
We do
11,
have- we
12.
do have lots.
No, but this,
You have existing
We
students.
have the accord permission since 2005 to open class 11.
Then
We are doing so.
and you have class
But in
11.
case, why I say that, my lord?
You have
Because,
12 also.
my lord,
Class 12 also.
yeah, 11, 12. Now my
Ah.
students are passed to class 12 and eventually all are passing also.
Ah.
My lord, why I say this? Because the other batch of writ petitions of mine is different and that has been kept apart and they have not filed a reply also in my writ petition. Is because my case is that every year I need to have 25 plus students to get provincialization for my school. Now, if you don't let me have my credentials, I'll not be able to onboard students.
What do you mean by credentials?
My credentials are logging in the Darpan. This is all online, my lords.
that is
My
why-
students have to be enrolled online. And last year also same problem has occurred. My lord, I have annexed last year's orders also, my lord, for my lord's convenience. My lord, will kindly take up page number 38 and 39 of my IA, my lords. 39, my lords will find the last paragraph.
Yeah.
Yes, my lord, if I may read the last two paragraphs. Learned Council as it clearly submits that the respondents may open the Darpan up to 9/8/2024. However, after the date, the portal will have to be closed in as much as it causes a lot of hindrance to respondent,
Where are
particularly
you
when the
reading?
my
It's
lord.
one 24, 25.
Which page are you reading?
Page 39, my lord, of my,
Yes, where? How does it start?
my lord, the second paragraph, Mr. T.C. Chutia.
Hey, there.
Yes,
Don't go straight away somewhere in the fourth word or fifth word.
I apologize. Learned Counsel, ASEC clearly submits that the respondents may open the Darpan up to 9/8/2024. However, after the date, the portal will have to be closed in as much as it is causing a lot of hindrance to the respondent, particularly when the examinations are nearing. After hearing the learned counsel for the parties, this I is disposed of by directing the authorities in the Higher Secondary Council to keep the Darpan portal open till 9/8/2024. The applicants are also directly approach the authorities in the Assam Higher Secondary Education Council on or before 9/8 by submitting all relevant documents for verification of the same by the authorities. Thereafter, the ASEC shall verify the documents and pass appropriate order for the eligibility to get admission to the state portal. It is made clear that the portal Darpan shall not be open beyond 9/8. So my extension was granted to me. My lord, after the granting of this extension,
To allow the facility of submitting online applications for
Yes, madam.
applicants.
That
Yes.
was a 24, 25 session only. The petition is, his petition is only for 24, 25. Now 25, 26 is yet to become. So
Madam.
this notification issued by the council, only after declaration of result, they will open the portal. Now, how in advance they will open the
No,
portal?
because this notification has said 1/4/25 to 8/4/25.
Those who have got permission for that matter, not only for that. However, second,
No,
third
no, please
paragraph,
read the top. As
however,
such, as such, second paragraph.
this is, all such, as such, all such institutions registered on Dorpon portal are directed to visit online to update their institution profile using the existing login credential on 1/4/2025 to 8/4/2025 in order to process the admission student class 11 and class 4 session 2025-26. This is different thing. They are not belong to that. They are belong to 22, 24 and 25 session yet to be decided by the court. That was the by virtue of interim order, they were allowed only. Even if the order pass against them, they will be rejected.
Okay, there is a earlier writ petition.
Yes.
There is a pending case.
Pending case.
but my case is different, my lord. What they are
Yesterday, 8 petition heard. 8 petitions were altogether they were heard. The Arjun Das 3/22/2024. It's the same matter, my lord. And in petition, same matter. This notification does not harm him because the e-portal will be open after declaration of result. If they have got the permission, they departed. They have not got the
No,
permission.
no, so this notification is not correct, that means.
No,
If the-
yes, it is not applicable to him because he does not have
It
his
is, what do
permission.
you mean it is not applicable to him? If it is not applicable to him, who is it applicable to?
Those who have got the permission from the DSC, private approval is necessary as per our regulation. That these are by virtue of interim order, those who are not getting permission will be allowed to get registered, subject to result of the writ petition. That is the order. So this extension is subsequent petition file. That's why court extend.
That is not reflected here. That is nothing.
by the permission that my senior sir says.
Yeah,
That permission I have obtained in 2005 already. That is annexure 2 of my writ
He said that
petition.
he's got permission since
Got permission,
2005.
I'm already on.
Provincialization is a different thing, but we are not
No,
about.
no, class 11, class 12.
I'm already
Yes.
having students, my lord, and they are passing every year.
Let them show the permission, my lord. How he
My lord,
have got it. from
Annexure 2,
government.
page 41. of
Just
my
a
writ
minute,
petition.
let me know. I don't understand what your case is. Please tell me the case from the
My lord.
beginning. What is it about?
My lord, in short, I'll explain. This,
What is the writ petition about?
my writ petition is for the provincialization of the services of the teachers and non-teaching staff of the school. Now, and,
Okay, so you're not a provincialized school.
no, my lord, but we have got the permissions to open class 11 by the virtue of 2005 accord.
Ah,
Now, my lords, the section 3 of Assam Education Provincial Services of Teachers and Reorganization of Education Institute Act says that for the services of the teachers to be provincialized by 3/5, 3/5, I need to have 25 number of students every year passing from my school. This is what the act says.
Okay.
My lord, now when I approached the authorities for my provincialization, they rejected my provincialization. Again, I went on section 14 appeal, and again it was also rejected. By virtue of it, I came before this honorable court by filing this writ petition. This writ petition says that I have been maintaining
which writ petition? This writ petition.
this writ petition. It's
Ah.
still pending. They have not filed the reply yet. My writ petition categorically says that I have been maintaining every year more than 25 number of students, so I am eligible for the provincializations of my school and the services. My lord, now every year they open the government profile and say that you have to get your students and yourself credential logged in the profile to get admissions. My lord, if I'm not able to get admissions itself, then I'm cut on the routes. I'll never be able to be satisfy the 3-5 provision, my lord. I'll never be able to have 25 more students or any student for maybe. Now this notification.
So now it
stops
says
from
that it is open till 8/4, till tomorrow.
Today, my lord, today.
Then so,
So, my lords, if I may be allowed to give a representation to them, and they allow the system to accept my credentials, I'm obliged in this IM. There's nothing
No, it is
further.
not open, my lord. It is not open. It is
I'm
different thing.
not able to.
Those who have got the permission.
but that 25 students is for the entire school or for the
They
class
are-
11?
Yes, and
They are not
by
part of the
virtue of the
school.
order last year, I was able to obtain 51 students.
No, I'm still not getting it. I'm still not getting the issue. And
The lordship kindly see page 2. This is a procedure. Page 2, application for permission to start higher secondary school at junior college. Just skip it, lordship, next paragraph. Such application shall be made in the prescribed from 1A, 1B, 1C according to application. Next paragraph, my lord. In case of existing government and provincialized high school, that is up to class 10 is provincialized. The higher secondary school recognized by the board council. The sponsor shall be the government of Assam. Application for upgrading, starting additional stream or subject shall be made by the headmaster, principal of the institution concerned, together with a copy of the GOP order with its back. So without any GOP order, my lord, they are not entitled to get it, my lord. Open it, open class 1 and class.
where is your class 11 permission?
My lord,
No,
annexure
nothing.
to page 41 of my writ petition. Annexure to page 41.
Page 41 of your writ petition.
It is not ordered.
Page 41.
Yes, ma'am.
With reference to above,
Annexure to.
I am directed to inform you that government is pleased to accord permission to open first year higher secondary class in arts stream in respect of Gangarabari Higher Secondary School, Morigaon, subject to fulfillment of all conditions and on condition that government will not bear the financial liability in terms of permission accorded. The undertaking to the effect may be obtained from the managing director of the school and will not claim any financial benefit. This is a letter issued by the deputy secretary to the director to see to open first and 5 class subject to condition.
My lord, by
They
virtue of
have to
which-
fulfill the condition, then they will give.
Have you fulfilled the
Yes,
condition?
my lord,
Where
I'm
is the
having students every year. My lord,
No,
please-
no, no,
Let
no.
them
Where
finish
is
the
your,
petition, then they will come.
My lord, may kindly see page next.
just a minute. Where is the undertaking given by the managing committee?
Nothing.
Look, there is no dispute with regard to my 11 enrollment of students.
Mr. Chutia, look, you have not filed any affidavit in this.
Manad, we have common affidavit file, same matter, Manad, we will, if necessary, we will file in this case also. Because the earlier occasion, both, all the petition were same. That we were common affidavit, the order was passed. Matter was hard. In this regard, we will file again. We will file affidavit.
My lord,
And this notification will not harm him. If he get the allowed the petition, my lord, then automatically he will get it for admission. This only eight for only those who have got the permission. Accordingly, they were allowed to.
You have not been given the permission.
Yeah.
my lords, for class
He will
11,
not be loser, my lord. He will not be loser.
This only says that
Since
the
2000
conditions has to be
my
fulfilled.
lord, since
He is apprehension
2006
only.
Huh?
Since 2006 till date, we have been maintaining class 11 students, my lord, in our school.
Maybe,
different thing,
maybe, but where is your permission? This is not a permission.
Maintaining only student not. He have to have some land, library, so is and everything fulfillment. After fulfillment of all these things, his school will be provincialized. This is separate chapter. First chapter is the permission. Permission, they don't have the permission. That's why portal is not open for them.
My lord,
By virtue of the interim order, they are
Okay.
if I'm not,
So he is asking.
I'll file affidavit, my lord.
my
No
lord, if I'm
interim
not
order is
able
there.
to get students,
No, no,
how will I satisfy 3-5? How will I have 25 minimum students, my lord?
How did you get it last year?
We got it by the virtue of the identity model that was passed by the
And
Congress.
how did you get the year before?
My lord, the year before they were told that all the students in the vicinity, they got enrolled. But now since an admission process is online, so we have to get everything online.
And unless you get it through the DARPAN, you cannot get
We did
provincial
not
ID.
get it, my lord. 51 students from the vicinity admitted, my lord, in my school. Highest number all this years.
Maybe Balatu, without any permission, Balot, they're doing the business. So the government has
Ah.
taken, government has taken.
One thing is that, you see, to
Mushroom
open
growth
a
of it.
class 11 school, you need the permission of the
Permission
government. Where is
is
the
there,
permission?
My lord,
There is
Permission,
nothing
but permission requires 25 students. Is it?
yes.
Without any
Where is
permission,
the conditions?
without any permission,
petitions
taking
are
the
free,
fees
fine,
from
my
the
lord.
students. That is the government has taken this decision. The mushroom growth of schools anywhere in Assam. Just the
Okay.
government have taken decision that every school has to have a government permission to open first year higher secondary and second year. So they have failed it. They are only running the student, taking the fees, running the business.
My lord,
That is the problem.
my lord,
Nothing is-
section 3I says.
But why are you not giving him permission?
Permission, they have to fulfill the condition. They will have to.
Which condition
No,
has
no,
to
no.
be
They will
fulfilled?
have to obtain prior permission from the director of secondary education.
I agree.
Yes.
We know.
Yes.
But why have you not given permission? We know that he has
No,
to get.
we are not. We are council. The government is there. The government.
Yes, madam.
No, we are not.
Yeah, who are you?
I am for council.
Which council?
Higher secondary council. I am the standing council for higher secondary council.
He's responsible
Because
for the
Dor-
Darpan. He's responsible for the Darpan credentials, man. He allows me for the.
We
Darpan
are
credentials to be
our
online.
business only to.
Yes, madam. Why aren't you giving him provincialization? On what ground? Why are you rejecting?
Does not the criteria.
What is the criteria to be
As per
fulfilled?
your lordship petition, they have filed your lordship. I would like to take your attention, page 76 of this brief petition.
Yes.
Second paragraph onwards, your
Yeah,
lordship.
yeah.
I would like to read it.
Yes.
As the report received from Assam Higher Secondary Education Council, Bamuni Moidan, reflects is that the total number of students appeared in the year 2014 to 21, then 2015 to 25, and 2016 to 2019, respectively, as per tabulation
Wait,
register.
What is it? How much is the
It is
tablet?
concluded that Dongabori Higher Secondary School under Morigaon district does not fulfill the criteria for provincialization of service of teaching and non-teaching staff of the school, as section laid down under 315 of the Assam Educational Provincialization of Services of Teachers and Reorganization of Educational Institution Act 2017, as amended in 2018. Here, your lordship, it was clearly mentioned that they does not fulfill the criteria.
Why?
as-
Why? It's like saying you have failed class 10 without giving reasons whether he got 0 marks in English or he got 99 marks in English. You have got to give some reason.
Reason order.
Yeah.
Your lordship, in the venture educational institution, minimum, your lordship, total enrollment would be needed, your lordship, 25 students
Okay.
in class 10. It was written here itself, your lordship.
Eh?
And another.
So he
criteria-
says that unless the portal is open, how can I show the amount of students that are admitted?
Your lordship, as per-
Okay, it doesn't have to be in the portal.
No.
He
Your
can take admission on the basis of written register is enough.
Your lordship, it was not reflected because they have not been fulfilled the criteria.
There's so many
Otherwise,
criteria.
Madam,
Contain the roots and how will I be able to
There
fulfill
are
the
so many
criteria?
criteria. There has to be a minimum lead, using.
Mister, I know all that.
I mean,
Now the question is, you have to give the reason whether he has land or not. How do you know?
No, this party is director of higher.
Correct. So at least let them say, you don't know whether they don't have land or not. They might be having. They have to decide. They've got to say.
I
My
will,
lord,
I would like to take
my
the
petition
instruction, your lordship, in this regard, your lordship. I will satisfy you.
for
your
a moment,
lordship.
my lords.
Why?
Only on this topic. They say that they've been showing the order against which I have filed my district, saying that I've been not maintaining the adequate number of students for all this 3 years. This 3 years they have mentioned. And this is the only dispute. In Annexure 7, I have been maintaining that this is some discrepancy of record which after filing of the affidavit and bringing the record before my lords could be clarified. But at this moment, my lord, if they don't allow me to let inside the portal, how will I get students and how will they tomorrow fulfill the criteria? I will be able to fulfill the criteria of this 3-5. I'll never be able to fulfill
Page
it.
108, eligibility criteria, your lordship, educational manual act, your lordship. 108, eligibility criteria for selection of educational institution for provincialization of service. There late rules are so many, your lordship. So your lordship, in this under,
My
if
lord, I've only
he
hit
was,
by 3-5.
your lordship, let me complete your lordship. He was over, your lordship, lapping it. Your lordship, for that, your lordship, I would like to take instruction in this regard, particularly why he has not been permitted, your lordship. Without knowing your lordship, how can I say yes, your lordship, allow him? I cannot say, because as right now, your lordship, I don't have instruction.
My lords,
And your
Madam,
lordship,
madam, this writ petition has been filed in May 2024. Now it is April 2025.
All the same page, Ballot. Last yesterday we have the transit credit. It's the same people were together.
Oh.
Yeah, how it is separated? I don't know.
separated,
Let it
gets
be hard.
segregated.
Let it be hard.
Anyway, this issue of portal opening, we can always do it later on.
Suppose 2025-26 is not open. Suppose he is deprived of, then he will come before your lordship that I have got the permission, they did not allow me. Then lordship allow and we allow them.
No, but by that time, there might have been.
One instruction about-
Deadline
I
is
will hit by 3-5.
8/4/2025.
No, but then you need a permission to
I need
open.
some
the
time,
school.
your
My
lordship,
lords, I have that
instruction.
permission.
Where is that?
That is, my lords, the Annexure 2 that I've shown, my lords.
That is not a permission.
My lord, suppose that I have been allowed for all this long years to get students on class 11. My lord.
Yeah. Page, what is that? Page?
Page 2, my lord, page. Annexure 2, page 41, my lord. And why I say that because the section 3 of the act says the venture education institute which have been established and have obtained the required permission, recognition, accreditation, concurrence, as the case may be required for the concerned institution from the respective competent authority or authorities on or
You
before.
will come on the
2006.
last day. You'll
My lord, what I proposed to
take
my lord.
surprise. You surprise the court also. Yes.
My lord, I may make a proposal. My lord, admissions are subjected in the month of May.
Yes.
I still have some breathing period, if my lord allows, that only my credentials be allowed on this moment. Subject to what they file.
I don't know.
My lord, why I
I
say that?
I
Because
want to understand the case. I cannot just pass an order without understanding the case.
Earlier, they are admission only on hearing of that, but for the paper.
Huh?
Earlier, they were allowed to only on the extent of the hearing order. They were subject to result of the petition. So yesterday matter was hard. What is the result of this color?
But one thing, it is your fault also. He has also filed a case. You are not answering.
In this case also, we'll file a benefit with the after support. We'll file in this case.
You file it?
Yes, we'll file. Because the common affidavit was filed, we thought it everybody will have each and every case would be.
How one matter has segregated your lordship?
This matter has come.
my lord, this is a bit different matter.
Anyway,
That's why
so
it's
there
kept
is
segregated.
a similar matter.
Otherwise, matter may be sent to the court number 20, but tomorrow we will heard. Already they have heard.
My lord, they are saying it's pending for.
Your lordship, I have received one instruction, your lordship.
No.
I'd like to place it.
So let it be followed in the court number 20 tomorrow. I will.
About,
What? Give me.
I have forwarded it, your lordship. Online.
End of that.
I hear.
Oh, David. Huh? Huh? List the matter on 11.
That instruction may be based on the record, your lordship. Dilute it.
Not, if I may say, until 11, if I be allowed to give a representation
No.
for allowing my credentials, he can come up with a reply on that day.
Your lordship, I have received instruction. I would like to file my affidavit also.
But Lord, this is the chance the school gets to enroll students.
I
Every
would like to
chance.
file my affidavit, your lordship. Because
This is a matter on 11, Ms. P. Das and learn counsel for the
secondary education.
secondary education and Mr. P.C. Tutia for the council. For the council submit that they shall file their affidavit within 2 days.
I am
This is the
appealing
matter
for
on
1, 2. 1, 2, 5.
Just give me,
1, 2, 3, and 5.
you're going to file it by day after tomorrow, within 2 days. Are
I
you?
have no option, your lordship.
You have option to say no.
I would like to file it, your lordship, because this would be the instruction. Instruction is very much with me, so I would like to file. Because categorically here, your lordship, it was clearly mentioned that he has not fulfilled the criteria. So your lordship, my stand is very much clear.
On 11.
You are talking about 2014, 15, 16.
Yes, your lordship, 2014, 15, 16, they have mentioned it, your lordship.
That is
But
their
what-
order, my lord. That is their rejection order on the basis of that. I don't have enough students. Where is my lecture 5?
But what about now? Now is not, these years is not being considered.
My lord, the
I-
inspector of schools have on 2020 given a report where
Okay, right.
it states I have 25%.
On 11th.
On 11th, my lord. It will not be replaced.
Deeply objects.